We resume the debate on the First Amendment as amended. And I think the next speaker is Deputy Scott, is that right? And then you fight on. Yes.
Yes, sir. I just wanted to explain. I won't be supporting Deputy Ballash's amendment because I actually agree with the Minister that the Minister's actually said rather than support something like this, he'd rather we reject it so he could actually to have a fresh start, and I think take into account some of all the information that's come out, I think, in this debate, and so for that reason, I won't be supporting the amendment.
Thank you, Deputy. Comment, St John.
Thank you, sir. So, with respect, sir, I'm not sure how this amendment was actually accepted for debate. Described by the proposer as a wrecking amendment, that is what it is. Sir, as others have said, I pay tribute to the scrutiny panel who've worked extremely hard over the summer recess, producing a very detailed report and have, in my view, been constructive with their amendments. So only yesterday, we as an Assembly endorsed the principles of the law, and it might be worth recapping them. To enhance security of tenure for tenants, principally through notice provisions and rent stabilisation measures, to encourage more settled longer-term tenancies for tenants, which also benefit landlords, to ensure landlords can continue to make a stable rental return and reclaim their properties when they need them, to establish explicit provisions that allow landlords to serve shorter notice to deal with unforeseen circumstances or bad tenants, and to ensure landlords and tenants have clearly set out responsibilities. So, these are sensible and balanced principles which make for a sensible and balanced modernisation of our residential tenancy legislation. So, like others, I've met with landlords throughout this consultation. The main concern shared with me was the 5% cap and the ability to move tenants on. The Minister has said he accepts Deputy Reynolds' amendment and also the amendment of no fault for no reason from the panel, 12 months notice. So that's why I'm happy to support his proposals. I note this morning in Deputy Ballash's comments about the educated person who had multiple rent increases not having a lease. My interpretation, I'm sure that of others, of his comments was that he put the emphasis on the tenant needing to know their rights. Well, with rights, sir, come responsibilities. And the landlord, sir, had a responsibility to provide that tenant and other tenants with a lease. So I was shocked a couple of months ago when I spoke to a landlord who told me they didn't know if they actually had leases for their tenants. This wasn't someone who'd just inherited a house. It wasn't someone who had a couple of properties and become a landlord by default. No, sir, this was someone who has been a landlord for probably 50 years on this island, someone who's a good number of properties around the island, both residential and commercial. How many others are out there like that landlord, sir? In addition to speaking to the landlord, sir, I also often speak to tenants. Sir, living in St John, and I'm sure other communities, people like to stay where they are comfortable and or where their friends and family live. And they are extremely reluctant to make a formal complaint to a landlord, let alone get an external agency involved, because they fear they won't be able to stay in the area they want to live. So I ask members to reject this amendment and stick to the principles that we voted on yesterday. Thank you, sir.
Thank you, Martin. Deputy Alex Curtis.
Thank you, sir. And I thought I would speak on this one because it may surprise members as a member of the scrutiny panel. I am minded to support Deputy Ballash on his amendment, but it is not necessarily for the reasons Deputy Ballash himself has brought it. I would like to put my views on this on record, and at this point I would like to give my apologies to the Assembly and to my parishioners for I will have a non-attendance. I'll be on defo for the remainder of the sitting. I have a family arrangement in the Southern Hemisphere based on where our family live, and it'll be the first time I have missed a sitting, so I apologise profusely for that. However, as we just heard from the Constable of St John, one of the key aims of this legislation is to improve security of tenure for tenants. And whilst there are many areas that this law will do, I believe the amendment that would bring back fixed terms tenancies will support that aim. We have heard that the Minister has included a reason that landlords may give to end a periodic tenancy. And this is provided almost as a relief for those who are worried landlords cannot regain their property. But, sir, I do not believe I believe there are certain instances where a landlord should not be able to regain their property from their tenant. I believe if a landlord and a tenant agree to a period of certainty, a period of fixed occupation, that should be respected. And this is important, especially when the landlord changes. A property may be owned by a person and that person may die and the property may be inherited. I do not believe it is right for a tenant who expected a long-standing stay in their property to find that notice cut short because a landlord changed and the property is now wished to be occupied. If they signed for 3 years, sir, and I believe they might sign for 2, they should be entitled to enjoy the premises for that amount of time. I think it is entirely wrong that landlords could unilaterally create advantageous systems for them. And that is why I was pleased the scrutiny panel amended Deputy Balash's to remove an imbalance of power. But I do believe it is right and fair for a tenant and landlord to agree that they can have continued and fixed and certain enjoyment of a property. And I do not believe that as long as we include safeguards, a landlord should be able to abuse that by shortly ending that, whilst obviously leaving an obligation on a tenant should they have wished to end it early. There are other areas we can continue to change, but I must also state at this point that I agree with Deputy Miller, and I think I made these points yesterday, about the risk that an RPI cap has. Many landlords do choose to increase their rent less than RPI. They believe a sitting comfortable tenant is more beneficial than following that. But I see a genuine risk that people will choose to follow the RPI because no matter that this would be passive, would you really want to risk, wish to risk having been called in and then justifying themselves when perhaps over the cumulative period of 3 or 5 years they are below RPI? The Minister may suggest that that's an unlikely case that the tribunal would then pursue, but we don't know. I believe that we must pursue those principles. I believe we are taking a step forward with a greater level of security for tenants if we adopt this amendment. It isn't perfect. I am disappointed that the legislative challenges that the Minister has highlighted at the article stage were not circulated to members in advance to give them clear understanding as to the waters they were walking into. He's been aware of them for quite some time. It's his choice. It's entirely his choice, and I respect he can make that decision. But, sir, for that reason, those are the positions I'm taking.
Thank you, Deputy. Does any other member speak on this amendment as amended? Constable St Mary.
Thank you, sir. I spoke yesterday as member of the scrutiny panel and emphasised I thought the main purpose of that debate, as indeed it was to get past first post by approving the principles. And the reason for that was that despite what many people say is lack of evidence as to the situation working generally, scrutiny has gone out to the public and received hundreds of representations made mainly by tenants, by some landlords, as to their situation. And whilst I fully agree with comments made by Deputy Balash and others that the present situation largely works, there is certainly a perception out there by a large section of the public that it is biased towards landlords. That is something we need to address. And basically, the proposition made by Deputy Messick, as amended by the scrutiny panel, if those amendments are carried, fulfills that purpose largely. As I say, so I speak as personally rather than a member of the panel. I already declare that I am a landlord. I didn't necessarily set out to be one, but converting 2 outbuildings to habitable accommodation provide the dual benefit of adding to the housing stock and giving me a pension. But again, I am perhaps more concerned than most, given that one of those units is within 5 metres of my own back door. I am concerned, or would be concerned, as to the quality of the tenant and the likelihood of problems arising. And when the proposition first came out, or its advance notice, I did have concerns. But through the scrutiny process, I have looked at each potential problem, and now I'm broadly satisfied that, particularly with the amendments made by panel, I as landlord need have no fears as to my security and as the possibility of getting rid of tenants should it be required. But I do repeat, so that my main point in addressing the Assembly now, sir, is that there is within the public domain a broad perception that tenants are badly treated. We do need to address that for the benefit of our society generally, and basically, whilst members have individual thoughts, and I don't question the validity of them as to certain provisions, they are free to vote against particular provisions as and when they come up. So my plea, sir, is therefore let the bill have the proposition have its day in court, so to speak. We need to show the public we have looked at this, we have addressed it, we have given full consideration to it, and if in the end result certain aspects are rejected, then so be it. But let's please proceed with the main proposition. Thanks, sir.
Thank you, Colin. Does anyone else wish to speak on this amendment? Deputy Jeanne, then Deputy Gorse. Deputy Jeanne.
Thank you, sir. I'm only going to speak to a few points because I think the Conotab of St Mary's summed up most of what I was wanting to say. But I would like to urge members to reject this amendment. And I say this because the Assembly asked scrutiny in July to work for them to look at the Minister's amendments and test it against a number of areas by examining the clarity of drafting, policy objectives, legal and financial impacts, and how they compare to other jurisdictions. And we've presented the Assembly with this report, within the annex also with the advisors' reports. So it's, as was pointed out yesterday, it's a long and detailed report showing that there is a complex to this law and to these amendments. But I believe that I think we should, and as the Conotab of St Mary said, we owe it to the public to discuss in details those different aspects of that the amendment law is proposing. We owe it to, I believe, I would like to, on behalf of the panel, to be able to persuade members and to discuss with members our amendments from scrutiny to show that the work that you've done, the work that you asked us to do, has been done thoroughly, and that we have these amendments to amend the draft amended law to, we think, to better give a better balance between a tenant and landlord relationship. And finally, I would advise caution. I would advise caution to supporting these amendments because it does, as we have heard, it does do some changes that haven't been completely scrutinised. The 2011 law, as it stands, was scrutinised before. So when it came in, it was scrutinised. So we know that where it was at the time, it was put there. Now, the draft amendments that have been put towards us have also been scrutinised. This amendment that Deputy Balash is putting forward to us has not been scrutinised, and for me, I would therefore just put some caution to that. And I would say that if you don't agree with the proposed amendment law changes, you don't agree with scrutiny, there are moments then when we go through the different aspects that members can still vote contre, and at the end whenever we get to it, we will then vote on the entirety of the changes to the 2011 law. There is a moment then again to vote contre. So I really would like members to or encourage members to reject this amendment so that we can talk about the details of the draft amendment law, the details that the scrutiny has put forward, and then at the end of it to be able to vote on our own consciousness how we feel that this amendment's law will be better for landlord-tenant relationships or not. Thank you.
Thank you, Deputy. Deputy Gorst.
So I'm not really sure where to start. I made my points yesterday on the principles about why I fundamentally don't believe that rent control works, and it certainly doesn't work to the advantage of tenants in the way that some are describing it to do. And that's where I have a fundamental problem. I also suggested yesterday that the amendments weren't necessarily as straightforward as some members might have thought. So we're left in a difficult position. I am minded to support the amendments, despite what some have said about the difficulty that might create to the wording, because I fundamentally disagree with what is proposed in rent control. And I remind members why that is. It is because I believe that landlords will end up increasing rents every year by inflation. Would have been by potentially inflation or the 5%, because how these proposals, how individuals act in practice can be very different from how they act in theory. And I give as evidence that the employment tribunal, many employers across our community have difficulties with their employees. They take legal advice and they make a ex gratia payment to the employee to avoid going to the tribunal. Only those employers generally who can't afford that end up before the tribunal. And landlords in practice will do what is necessary to avoid going to the tribunal. Some might say that is a good thing, but what is necessary will mean that they increase their rent every year by inflation to ensure they don't ever need to go to the tribunal when they're having, if they have repairs to carry out. And as we know, the way that the repairs exemption is framed is around what is of benefit to the tenant, and that's I can understand why it's framed in that way. So I fear that despite all of the lovely words about what will be achieved, the opposite will ultimately be achieved. And that's why I continue to maintain my opposition to the principles and the relevant articles. And as the chair of the scrutiny panel said, if Deputy Balash's amendments aren't approved, we will then go back and have the same arguments over the individual articles. I am, of course, prepared for that. I, on balance, would prefer the acceptance of the amendments, but we'll have the same arguments again. I personally don't believe, well, I think we can have the arguments as many times as we like, but it's with a heavy heart that I have them, because I just don't think it works. Thank you.
Thank you, Deputy. Does anyone else wish to speak on this amendment? Yes, Deputy Feltham and Deputy Renouf. Deputy Feltham.
Sarah, I'm pleased to stand up and say I obviously have more confidence in landlords than Deputy Gorst does, because I don't think that this change in legislation as proposed by the Minister would lead to the opposite effect at all. But what I really wanted to stand up and say today is what confidence and what respect I've got for our scrutiny process. And I know I've said this before in the chamber, but this is one of the reasons why I think that this particular amendment actually is so damaging, and it's not been presented in a constructive way, and it's really been a missed opportunity to put forward other amendments that the Deputy Mayor have wished to put forward that then could have been discussed within the overall framework so that more positive and proportionate changes could be made. But of course, the scrutiny panel have done that. The scrutiny panel have scrutinised on the request of the Assembly. I say that again, the request of the Assembly. We didn't take a vote on the principles back in June because the Assembly requested a pause and come back after scrutiny had looked at it. Scrutiny have done a great deal of work looking at this proposed legislation. And they've made some very constructive amendments. And I think that it is only just and right that those amendments that have been properly thought through and properly scrutinised get the opportunity to be debated today. The mover of this proposition, Deputy Balash, the leader of, I believe it's now called Advance Jersey, made no secret of the fact that this is a wrecking amendment. And I share Constable Jean's thoughts. I'm also bewildered as to why this amendment was allowed in the first place, because what it does do is stop that constructive dialogue, that constructive debate that then takes us to a point where we've got a piece of legislation that has been well scrutinised, that we have come to through the consensus building of this chamber. And I think those processes that we have within our rules and our structures that include the scrutiny process are incredibly important. And I think accepting this amendment, the way that it's been put, the way it's been put as a wrecking amendment, I will say that again because the proposer said it, really does I don't know what it says about the proposer's view of scrutiny. I'm actually quite lost for words there. So I'll repeat a point, and I'm afraid to repeat a point that's already been made, but if you are against the residential tenancy law as it stands, against amendments, you will get the opportunity, if this amendment doesn't go through, to vote against that later on as we discuss the other proposed amendments. But please don't waste all of that really good work that the scrutiny panel has done by accepting this amendment and curtailing the debate here. I believe that what the Minister has proposed is measured and proportionate. I believe in the scrutiny process, and I believe that that process has led to some really constructive and well thought through amendments. Unfortunately, I believe that Deputy Balash's amendment is less well thought through and would also leave us, and I don't think that we should forget this point, it would leave us with a legislation that doesn't work operationally. Deputy Curtis has admitted it's not perfect. Deputy Gorst acknowledged that there was difficulties with it. They don't have confidence in it themselves, despite talking and saying that they're going to vote in favour. What does that say? Me, I have confidence in the Housing Minister, and I also have confidence in the scrutiny process and the scrutiny panel. So I will leave it there, and I encourage people to reject this amendment.
Thank you, Deputy. In speeches today, more than one member has queried how it was that this amendment came to be approved for lodging. So I think I should reassure members, or at least indicate that this amendment was looked at independently, which means on their own, by the bailiff, deputy bailiff, greffier and deputy greffier, and then discussed at a meeting attended by the deputy bailiff, greffier and deputy greffier, and we all independently and collectively concluded it did not contravene the strict word of Standing Order 20. because notwithstanding its substantial effect, it could only be disallowed if it wholly negated the proposition. And for that reason, it was permitted. Deputy Renouf.
Thank you, sir. And my speech can be much shorter thanks to the recent contributions that have been made. I do want to start there with a comment I made back in July, which is that my starting point is that a dwelling is first and foremost a home. That is what I wrote in my manifesto. Housing is indeed a fundamental human right, and that colours my sense of where the balance lies in some of the issues that we're debating here. But I am also keen to ensure that renting remains a viable economic activity, not least since I'm a landlord myself, and that the private rental sector continues to thrive. So I come at this from both of those perspectives, and from both of those perspectives I find I cannot support Deputy Balash's amendment, or any part of it, in fact. I do think there's a few key assumptions that need to be challenged in the discussion that sits around this amendment. The first assumption is that the existing situation is essentially fine. The problem has not been evidenced, therefore the need for changes to tenancy periods and to rent setting are not justified and should be removed from the Minister's proposition as per this amendment. As I said yesterday, the evidence that things are not fine is there if you're prepared to see it. Maybe we will just have to agree to differ on this. I do not think I can usefully add anything on this matter to the points I made and others have made in discussing the principles yesterday. And a second assumption is that the existing legal framework allows all the things that the Minister is seeking to achieve. And again, I think because that is a fundamental challenge to the principles of this, we've had that debate to a considerable extent, and the Minister has explained that there aren't, and the examples that the proposer of this amendment suggested around, for example, the ability for tenants to bring legal actions and so on are undermined by the fact that without the Minister's proposals, the weakness of the tenant's position is such that they are unable to exercise rights which might exist in theory. The third assumption is that the clauses that Deputy Balash seeks to remove represent a dangerous threat to fundamental property rights. And this seems to rest on a slippery slope argument rather than the actual content of the Minister's proposals, which under any reading are very hard to argue represent a fundamental threat to property rights. I think that we should remember that property rights are not absolute. The current set of rights we have are not written in stone. There were no property rights in the Garden of Eden. They are rights that have been created by us. They are amenable to amendment by us. And we can amend those rights to strike a slightly different balance if we wish. But I would say there is a fundamental philosophical issue at stake with this amendment, as proposed by the Deputy, which I think, if I understand it correctly, I would say sum it up like this, is should we put in place legal safeguards for tenants, ones which I think are actually fairly minor ones, balanced by some additional legal safeguards for landlords, or should we continue to leave it up to the market to determine landlord-tenant contracts as defined under the existing legislation? I think the problem is that in the latter situation, we are essentially relying on noblesse oblige. It is based on an assumption that landlords will do the right thing, that they will accept their responsibilities to be good landlords, that they won't abuse the power that comes with being able to end tenancies, and so on. And I think that ultimately, I don't think that is enough. So if there's a philosophical issue here about should we entrench more rights in law, I say yes. Not massively enhanced rights, not rights that go beyond, go to the extent of what is being done in other jurisdictions, but I think, as the Chief Minister reminded us, we cannot rely on all landlords doing the duty. I think one other thing that's interesting is that there's a lot of anticipation here about how landlords are going to react faced with these proposals. And there is this idea that they will, for example, in Deputy Gorst's view, jack up rents every year in order to avoid going to a rent tribunal, or that people will, in order to avoid the, sorry, I've lost my thread there. I'll leave it at that with that one. I don't think that is the case for the reasons that I think people will quickly come to understand that there's no need for that, because you will know that in fact you don't have to go to the rent tribunal to have an above inflation increase. You simply have to explain to the tenant the reasons why you have done this. And only if the tenant finds those reasons to be inadequate will the rent tribunal be engaged. And that is a fairly simple thing to understand. The circumstances in which rents can be raised are fairly well understood. We all understand if property improvements are done, and no tenant and tenants are likely to understand that as soon as it is explained to them, and landlords will know that that is likely to be the case. It's been described, I think this will be the final point I make, that these proposals are a full frontal assault, I think that was the phrase used, on the private rental market. They really aren't. They really aren't. And I must admit to a slight feeling of déjà vu, having brought in the licensing of rented dwellings when similar arguments were advanced, that this would be a fundamental undermining of confidence in the market, and that we would see a decline in supply, rents would go up, there'd be people exiting the market, and so on. And I noticed a tit-for-tat email exchange over the lunch break about what the actual situation is, but there is no reading of the statistics that anyone presented which show a significant reduction in rental properties as a result of what has happened so far, or indeed the supposed threat of what is coming. Indeed, if I read the Minister's reply correctly, something like 50 new licences a month are being applied for. There may be reasons you might want to qualify that, I don't know, but whatever it suggests, it does not suggest a wholesale flight from the market in the light of either changes already made or changes that are potentially coming. And remembering that the changes that are coming are much milder than the ones that were originally proposed, which is one of the reasons I feel confident in supporting them, having seen the work that scrutiny has done and having made my own small contribution with an amendment as well. I'll close with one final thought, which is I have been amused by some of the commentary around this, suggesting that the Minister has some devilish plans, that he's able to he's come up with some amazing scheme here whereby he can't lose. I've seen this quoted in social media, that he's cunning in devising a scheme where he cannot lose, because if he wins the vote, it's a great triumph, and if he loses, then he can blame people and so on. I just think it's worth reflecting on why that might be such a cunning ruse. I think it slightly overstates the Minister's cunning and abilities here. It's just because they're popular. There's no great secret to it, is it? If he can't lose, it's because the proposals are essentially fairly popular. So I think there is an alternative narrative you could put to this. You could say it isn't great cunning on the part of the Minister to achieve a huge triumph for reform. You could say this is actually a triumph for the Assembly in moderating the policies of a Minister who maybe did initially go a little bit too far. And actually, we have here a good example of democracy in action and restraints and checks and balances working. And that might be a slightly better analysis of what has actually happened here. And I think, therefore, rejecting this amendment, returning to debate those detailed and thorough and well thought through proposals from scrutiny, which people can reject or not, or reject the whole thing at third reading, in whatever form it returns to third reading, feels to me to be a very sensible proposition, a sensible way forward. Thank you.
Thank you, Deputy. Deputy Catherine Curtis.
Thank you, sir. I was extremely disappointed when Deputy Balash openly stated that he'd brought a wrecking amendment. I don't believe that this is in the spirit of the Chamber. I've already made a speech on how important the proposition is to the whole island. I have to say I don't feel comfortable to be part of an assembly that votes for a proposition one day and then the next day votes for an amendment that effectively annuls the proposition. That does not seem honest to me. I don't think it puts states members in a good light to vote for this amendment. So I hope we can vote against it and move on to debating the original proposition that we passed yesterday.
Thank you, Deputy. Does anyone else wish to speak on this amendment as...
So I've got a question for the Attorney-General, if that's okay.
Yes, of course.
So the question relates to actually Article 16 of the current residential tenancy law. We've had a lot of discussion about the jurisdiction of the court, and I wanted to ask whether 16.1, where it says that the court shall have exclusive original jurisdiction over any matter relating to the residential tenancy law or to a tenancy agreement, and it goes on in that vein, whether in reality that means that the court has, in his experience, or does exercise that power, or whether there are limitations in reality as to what the court would seek to do or be indeed allowed to do under the current wording of that.
Attorney General.
Sir, the words used do confer a broad jurisdiction and an exclusive jurisdiction to the Petty Debts Court. And Article 16.4 of the current law says that the normal limit of the jurisdiction of the court to deal with small claims doesn't apply to residential tenancies or tenancy agreements. So it is a broad jurisdiction. And when one reads it with Article 14 on a stay of eviction, it does also provide, in the context of eviction proceedings, a jurisdiction for the court to vary the rent payable. So it is a broad jurisdiction as things stand. I have to confess that I have limited experience of the Petty Debts Court in eviction proceedings myself, and indeed members of my department have limited experience because since Andium has taken over the vast majority of residential tenancies, I believe these sorts of things are dealt with by Andium's own lawyers rather than my department's lawyers. If the deputy has further questions, I can do my best to answer them. But at the moment, on the current wording of the law, the Petty Debts Court does have a broad jurisdiction, including on an application for eviction and consideration of a stay of eviction. It does have the ability to, on its face anyway, on the face of the law, to vary the rent payable under a tenancy.
Sir, could I ask a follow-up question, please?
Well, Talia, any further questions from you first?
To the Attorney General.
Deputy Scott, yes.
I'm okay for now, thank you. Thank you
Scott.
to the Attorney General.
Thank you.
Thank you, sir. Just looking at the same provision, because the amendments are, if the actual minister's amendment would insert a new 1A into 16, which would say, but the court has no jurisdiction over a matter for which the Rent Tribunal has jurisdiction under Article 13H1. So if you look at 16.2, it says that the court in relation to residential tenancy or residential tenancy agreement could, if satisfied in all the circumstances, be just to do so, make an order as to arrears of rent, repayment of rent or repayment of any deposit and all these things. Am I therefore, but if you actually amend that and say, well, the court has no jurisdiction over a matter which the rent tribunal has jurisdiction, to what extent does that restrict the court from actually exercising its powers under Article 16.2, please?
So the Minister's amendment, the Deputy is quite correct. It does provide that the Petty Debts Court doesn't have jurisdiction over matters for which the Rent Tribunal will have jurisdiction under the Minister's proposed amendments. But in terms of the Minister's amendment to provide the jurisdiction of the new Rent Tribunal, so that's dealt with in new Article 13H. So 13H provides that the Rent Tribunal, if established, will have exclusive original jurisdiction over matters that it may decide under Articles 7E and 7D4. So those matters are to do with the amounts of rent payable and the tenant's ability to apply to the Rent Tribunal for a decision on a rent increase. In my view, sir, there is a sufficient separation under the Minister's proposed amendments that the Rent Tribunal is to deal with matters specifically concerning rent increases, and it does preserve sufficiently the rest of the Petty Debts Court jurisdiction in relation to other matters, and particularly concerning evictions and stay of evictions. So both the Petty Debts Court and the Rent Tribunal will obviously have to be careful not to trespass on each other's respective jurisdictions. But in my view, sir, the Minister's proposed amendments sufficiently set out in sufficiently precise terms what those two respective jurisdictions are to be.
So just to be clear then, where this court's jurisdiction is includes, or under this Article 16.2 says it may make an order as to arrears of rent. If that rent has actually risen as a result of a rent increase, does the tenant have to go to the Rent Tribunal in order to establish whether the increase is fair or not, or before the court can actually just say, make an adjustment?
The Deputy raises a good and valid question. I think that will have to be a matter that will be worked out in arrangements between the Petty Debts Court and the Rent Tribunal, because I accept that might well be a question that arises in practice, but I think it could quite easily be dealt with in perhaps some guidance or practice directions issued by the respective Petty Debts Court or the Rent Tribunal. So I don't see it as an overriding objection.
Just going back to Article 14 about the stay of eviction, which hasn't been touched by the Minister's amendments yet. I think I see that Deputy Balash is touching the amendments. I just wanted to see if I'm reading that right from that the point 10, page 63, Article 14, delete Article 14.2 and delete Article 14.3, which is part of the stay of eviction, which is currently in the 2011 law. So I was just wondering what that would have as an effect on the court if that is deleted, which wasn't touched by the Minister's amendment. So this is a new, in a way, it is bringing a new aspect to changing the 2011 law. Is that my reading is correct on that? It's point 10 of the Deputy Balash's amendment.
Sir, if I can have a moment, I read that as referring to the Minister's amendment, so that I read that as a new Article 14.2, or under the amendment. But if I could just have a moment to check that, please, sir.
Yes.
So could I propose a 5-minute adjournment? It might be wise. We're coming to the end of the debate and we would like to hear what if it's helpful, if not.
Well, you need 5 minutes? We can always come back to you.
I'm happy to be come back to, sir.
Yes.
I think the problem is there's only a few speakers left and it might be helpful to hear
Well,
what
we may be optimistic. We don't know how many there are. Should we find out? How many members wish to speak still on this before we get to the response by the proposer? You want to speak, Deputy? Anyone else wants to speak, Deputy Kovac? You able to speak now whilst the attorney does his work, Deputy Kovac? Prepared to make your speech now? Yes, Deputy Kovac.
Thank you, sir. So we are asked today to consider an amendment to the tenancy law that I have to repeat it myself as well, that even Deputy Balash himself stated proudly that it is a wrecking amendment. And he is right, because it would wreck the progress we are trying to make for tenants, for families, for fairness in our housing system. This amendment does three main things. It removes rent control and the rent tribunal, it scraps mandatory periodic tenancies, it rejects civil penalties. And the deputy defends contractual freedom, warning that the changes would undermine Jersey's legal traditions on properties. So is this more about not breaking tradition and fear of change, even this might prove it's a balanced improvement? I want to go again very brief over what these points mean in practice, as I see from the questions asked that there are still some unclarities. For tenants, without rent control, landlords could raise rents as high as they wish, whenever they wish. In a market already stretched to breaking point, that would leave tenants vulnerable to sharp, unaffordable rent hikes. Without periodic tenancies, landlords would be free to evict tenants without needing a clear reason. That means less stability, more fear, more families wondering if they still have a roof over their heads next month. And without civil penalties, tenants who face unfair treatment would be forced to go to court. We all know court action is expensive, intimidating, and simply out of reach for many. In reality, it would leave people with rights on paper, but no power to enforce them. For landlords, this amendment gives them more power to set rents as they please, to end contracts as they please, and to avoid oversight. But let's be honest, that flexibility comes directly at the expense of tenant security and fairness. For the housing market as a whole, removing safeguards will not solve our housing crisis. It will make it worse. Vulnerable tenants will be priced out, instability will grow, and inequality will deepen. Long-term renting will become even less viable. That is not sustainable. Sir, this is not about punishing landlords at all. As stated before, for the landlords doing the right things, nothing changes, and the claim of extra bureaucracy brought again by Deputy Balash has already been proved not true by the Minister. The new tenancy law proposed without this amendment is about balance. The Minister's proposals aim to give tenants a fair chance of stability, predictability, and dignity, while still leaving landlords with the ability to earn a fair return. Deputy Balash frames this as a matter of ideology. I disagree. This is not about ideology. This is about families who cannot plan their future because they don't know if they'll still be in their home in 6 months' time. It's about workers who cannot save for a deposit because their rent rises faster than their wages. It's about fairness, security, and human dignity. I repeat that from what I said yesterday. Investing in property is a business decision. Like any business, it comes with risks as well as rewards. But when that business is about people's homes, where children grow up, where families find security, we as legislators have a duty to make sure basic protections are in place. Let's not weaken this legislation. Let's not strip away tenant protection. Let's not pretend this amendment is anything but a step backwards. I ask you to reject this wrecking amendment so we can move forward to the next amendments with options of a stronger protection, a fairer system, and a housing market that serves not just investors, but the whole community. Thank you.
Thank you, Deputy. Attorney, you ready to respond to this question?
Yes, sir. I confirm my original answer to Deputy Jones' question. So Deputy Balash's amendment at number 10 of his amendment refers to the Minister's amendment on page 63 of the Minister's lodged amendment, which relates, it's number 14 of his amendment, but it relates to Article 15, not Article 14. So it's not amending Article 14.
Thank you, Attorney. Deputy Tadia, do you wish to speak now?
Unless Deputy Gorst wants to speak.
He's spoken already.
Oh, good. I'll definitely want to speak then. Thanks. So I'll be brief because I think a lot's been said. Just to start off by saying, because we're still on Deputy Balash's amended amendment now, and I think we've had a wide-ranging debate, but the first observation is that I didn't have Deputy Balash down as a Miley Cyrus fan, so you learn something new every day. He did come in like a wrecking ball, and he was quite happy to admit that. And it's already been a wide-ranging debate. We've heard about not comparing imaginary apples with, or symbolic apples with symbolic pears from Deputy Scott. My recollection is that René Magritte, who did Ceci n'est pas une pomme, was part of the Surrealist movement, of course making a comment on symbolism, but perhaps he's also, I certainly wasn't familiar with that one, but it's part of a series, Ceci n'est pas une pipe, where there's a picture of a smoking pipe saying this is not a pipe, is perhaps more appropriate for this amendment because there has been a lot of smoke and mirrors up until now used in this, I think in this amendment, but also in the more general debates. I want to compliment not just the scrutiny panel as I did yesterday, but actually the Minister for Housing, because I thought he gave a very good account in very clear language as to what this amendment does in reality, and the spurious comparisons. We haven't been comparing apples with pears. Some have been trying to compare this housing proposal from the Minister with haggis, it would seem, because this has got nothing to do with the Scottish rent legislation either. As the Minister quite clearly said, it is a completely different animal. In fact, he has taken into account all of the arguments that have been put forward, I think, by wider society. And also, just to add, from my experience of Jersey civil servants and the officers that work with ministers, is that they're inherently cautious individuals. They wouldn't be advising any minister in such a way of anything that is unlikely to be well balanced and certainly not something that wouldn't get through this assembly. So these are by no means radical proposals when taken in the wider consideration, and I think the minister's been very clear about that. So I think it comes back to that idea of the apple. There are many ways to cut an apple, of course. Deputy Renouf said that there were no property rights in the Garden of Eden, but there were apples in the Garden of Eden, of course. And we know that apples can certainly cause a lot of problems. What we're trying to get to here, sir, is a balance between the rights of tenants and the rights of landlords. It shouldn't be beyond the wit of us to be able to do that. And certainly this amendment brings nothing to the table. Actually, we reiterate at the end of this debate, before Deputy Balash will have the chance to stand up, that he deliberately brought this as a wrecking ball amendment. I'm going to have that song stuck in my head this evening, I'm sure many of us will. But what we don't have to have is an unworkable law in front of us that puts the minister and his officers in such a position that actually it would have been better that we just vote against this in the final reading. I don't think that is an inevitable conclusion. I think what we have in front of us without this amendment is something which will be entirely workable. It will be something that can be in some ways filled in with the consent of all of the community as we go along, sir. And I ask and urge members to reject this amendment, sir, and to let's get on with the main part of the debate to consider this and hopefully by the end of the day pass something meaningful for the first time. I know, of course, looking over to my other colleague who hasn't got a mention yet in St Brelard, Deputy Helen Miles, is doing some very good work around Lekena Bay Precinct to bring in some similar controls, I think, which are much needed around the commercial sector. It would be completely illogical if we were to say that we want to protect, I think, commercial tenancies, which I think is absolutely the right thing to do, when we've got thousands living in precarious situations in our island who have been crying out for decades for better and more secure and clearer housing rights. And of course, nothing in the future will stop, I think, what Deputy Balash has mentioned, what Deputy Scott has mentioned quite rightly, that tenants do need to be informed of their rights. There's absolutely no reason that the Minister, that Citizens' Advice and government more widely should not be informing tenants of their rights, but there needs to be something that's workable in place. And the final thing I would say is that the reason I asked that question about the residential tenancy law is I have accompanied somebody to the Petty Debts Court, but for the housing side of it, because they're the ones who deal with it. And there is a stigma for both parties in going to court, because court is associated with criminality, with an offence. We're actually, when we talk about a tribunal which has been set up specifically to deal with housing matters, there isn't that stigma. It's seen as a civil solution, a civil resolution, one which may actually be a last solution before mediation might take place, and it doesn't have that same stigma that a court might carry. And courts don't inherently like getting involved in contract law. You know, these are decisions that are made between two consenting parties. It's not something that the Magistrates' Court, in my experience, likes to get involved with. When I asked them on behalf of somebody I was supporting, I couldn't obviously have rights of audience, but when she asked for them to take a wide view of Article 16, they simply didn't want to get involved in setting precedents in housing cases, which might, of course, have a domino effect later on. So this is absolutely the jurisdiction for a rents tribunal, and I hope we can all get behind what the Minister is trying to do with the wider picture.
Thank you, Deputy. I call upon Deputy Balash to reply to the debate.
Thank you, sir. I want to make just a few key points, some of which relate to the economic impact assessment from the government's head of economic analysis. And I think this is a really important document. The Chief Minister is to be congratulated on commissioning it, but it is disappointing that it was not made available to members much earlier. It is undated, so it's not clear when it came into existence, but it should, at the least, have been made available to members for the debate on the principles, because it was highly relevant. I hope that all members have had the opportunity now to read it. These are substantial amendments. I should not have used the other word. Substantial amendments to the proposals, but they have to be. The rent control provisions, for that is what they are, the establishment of the rent tribunal, the incorporation of the periodic tenancy, together with the inability to bring it to an end other than in defined circumstances, are all fundamental changes to the law of landlord and tenant. So the first important point to make is one that has been made by me and several other members during the course of the debate, and it's to be found at the first paragraph of the Economic Impact Report. And it states, while the RTL says that these amendments are needed to both update and improve the law, it does not provide any evidence on the problems or issues that the current law is causing, i.e. the problem that the amendments will address, nor does it provide any data on the number of tenancies, landlords affected by one or more of the proposed changes. And then it carries on, the lack of information on the scale and nature of the problem make an economic impact assessment difficult. In other words, these substantial changes to the residential tenancy law cannot be objectively assessed from an economic perspective because there is insufficient data to do so. The report doesn't say that it's impossible to obtain that data, it just says that it isn't there. For an assembly to plunge into the dark in this way is, in my view, irresponsible. We are making major changes which may adversely affect the island's economy without having any idea of the likely consequences. The Minister criticised Deputy Gorst's speech yesterday on the former rent tribunal scheme as being irrelevant, but it was not. The account of people's manoeuvring to avoid the adverse economic impact of price controls is exactly what happens in those circumstances. The market will protect itself. How exactly the market will protect itself against these intrusions into contractual relations is unknown, although the impact in Scotland and Ireland enables us to hazard a guess. And I'm sorry that the Minister doesn't like these references, but the fact of the matter is that the Scottish approach to limiting the right to increase a rent is different indeed and more advantageous to tenants, but it is in principle exactly the same. We have been warned. The report states at paragraph 2, the private rental market is essential for Jersey's economy. Essential is a strong word. We mess with the market when we don't know what we are doing at our peril. The report concludes with these words, because the residential tenancy law does not evidence the problems or the scale of these problems it is correcting, it is not possible to assess whether, on balance, these amendments offer a net benefit to Jersey's economy. The Minister, in his speech, Sir, asserted that the amendments, my amendments, cause technical problems to the interpretation of the law, and I reject that assertion. I have already explained in relation to the retention of Article 8 of the amendment law, which deletes Article 9 of the existing law, which gives the court a power, a statutory power to terminate an agreement of premises if the premises are uninhabitable. All that is true, it does do that, but the customary law already gives the court a power to terminate or vary an agreement if a fundamental basis of the contract has gone, if the contract has been frustrated. If the premises are uninhabitable, they obviously cannot be let as residential accommodation. We do not need an additional statutory power, and indeed we did not have one before 2011. These changes do not compromise the integrity of the amendments that I have lodged. If they did, I am sure they would have been picked up by the GREF or by the Legislative Drafting Office. So 2 material changes have been brought about by amendments from the scrutiny panel and Deputy Renouf, accepted by the Minister. The 5% cap is going. and there is going to be a 12-month notice period for landlords to recover their property. Do these change the picture so that members can take the risks outlined by the government's own economist? I don't think that they do. The impact assessment says that the amendments will generally be of benefit to tenants, although how many is uncertain. Some tenants will benefit from the move to periodic tenancies, but not many, because most of them enjoy it already. Some will benefit from rent control, although the scrutiny report says that RPI increases are already best practice and widely accepted. If tenants could be better informed as to their legal rights, it would be almost universal practice. These monumental changes, for that is what they are, will affect, in practice, very, very few tenants. But they will affect all landlords. Compliance, says the report, will cost landlords a whisker under £300,000. These amendments are not balanced, despite the protestations to the contrary. They are tilted against landlords because the minister has an ideological fixation that the law is tilted against tenants. But the important problem with the minister's proposals is different. The main worry is what they will do to the economy, as Deputy Barbara Ward pointed out yesterday, and who has been vindicated by the economic impact assessment. Paragraph 5 of the assessment states, the amendments can be expected to elicit some unintended behavioural effects by landlords. Some landlords may feel that the pace of change effect of the amendments is to make letting unattractive, and some landlords may be deterred from investing, and some potential landlords may be deterred from entering the buy-to-let market. The report states neither outcome is desirable. Fewer new developments could affect the supply of new homes for islanders, which in turn will have an effect upon the island's economy. It is the perceived and indeed actual assault upon the interests of landlords which is the worry. Confidence, as the late Senator Cyril Lamarck used to say, is the name of the game. There is no confidence that the 5% cap will not be reinstated, or indeed at a lower level. The 12 months provision for giving notice without a reason does not remove the central concern that a landlord's property is not any longer really his own. If the owner cannot regain possession of his own property by giving reasonable notice to his tenant, should he let it out? At some point in the future, 12 months could become 24 months, or indeed be removed entirely, as the minister wished. As the minister rightly put it, the balance of power is shifting, and that shift is what will affect the confidence of landlords about investing in rental property, and in turn will affect the island's economy by reducing the numbers of rental properties, which in turn will increase rents because of the scarcity of supply. If members do not accept my amendments, I submit that they are playing with fire.
Deputy Balash, in terms of members voting on your amendments, you've grouped your amendments into three titles, as it were: capping of rent increases, establishment of rent tribunal, then periodic tenancies, and then civil penalties. Do you wish members to vote on those three categories?
Yes, please, sir.
Yes. The Appel I believe has been called for. Members are invited to return to their seats. And members, we first be voting on the amendments moved by Deputy Balash under the title Capping of Rent Increases and Establishment of Rent Tribunal. I invite the greffier to open the voting.
Sorry.
All members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce that has been rejected. 21 votes pour, 24 votes contre.
Could we have the votes on both sides, please?
Yes.
Those voting pour, the Connétables of St Bralard, St Clement, Grouville, St Ouen and St Saviour, and deputies Labby, Luce, Morel, Ayer, Gardner, Gorst, Balash, War, Scott, Rose Binet, Miller, Howell, Tom Binet, Ferry, Barbara Ward and Wilson. And those voting contre, the Connétables of St Helier, St Lawrence, St Peter, St Martin, St John and St Mary, and deputies Southern, Tadier, Doublé, Lehegara, Rob Ward, Farnham, Mezek, Porray, Miles, Renouf, Catherine Curtis, Feltham, Jearn, Kovac, Stevenson, Andrews, and online deputies Coles and Else.
I'll move on to the second vote, dealing with the amendments relating to periodic tenancies. I invite the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. And this amendment has been rejected by the same margin, 21 votes pour, 24 votes contre. The third vote deals with civil penalties. The amendments in relation to civil penalties. I invite the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. And again, the amendment has been rejected, 21 votes pour, 24 votes contre. So we now move on to the second amendment proposed by the Minister for Housing. Again, these amendments are extensive and I propose to take them as read by the greffier and invite the Minister to propose the second amendment. Minister.
Thank you, sir. We have a running order in front of us, so it just might be helpful when we are getting to these amendments, just be reminded exactly which parts it is, because even though there are
packages of amendments that are consolidated in a single amendment document. We're not necessarily dealing with all parts of that in each debate. So my understanding now is that I'm proposing part 1 of the second amendment, which affects Article 6. Can I just be sure that we're all under the same understanding on that, please, sir?
Deputy Jern, you had your light on.
Yes, I was actually going to ask that same question because I was wanting to request that the Minister takes part 2, 3, 7 and 11 ending an initial term early separately if he was going to do it en bloc, but as the Minister, I think, is going to do it separately in what he's just proposed. And
So you're proposing to take which parts, Minister? Simply the first few amendments?
the parts 2, 3, 7 and 11 together, which deals with ending an initial term early, to take that separately if the Minister was going to take Amendment 2 en bloc, but because of what he just said, I'm not sure if...
Yes. Yes. Minister, we were proceeding on the footing having regard to the running order that the Assembly would debate and vote on the second amendment. But you're simply going to propose it and then have the amendment B2 considered by scrutiny. Is that what... The running order says the Assembly debates and votes on the second amendment. Unless I'm looking at the wrong page. No, I'm looking at the wrong page. Sorry, I'm looking at the wrong page. You simply propose the... Just say... It does say debates and votes. Yes. 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 Well, Minister, the running order does say, which will seem that the Assembly debates and votes on the second amendment as a whole. But if that's going to create problems for your scrutiny, then we can certainly approach it differently.
So just my reading of it is that I could propose the second amendment as it is, but if scrutiny wanted to have a separate vote on that part, then I could attempt to do that.
Yes. Falls away. Second is adopted. And then we move on to the yes. Our understanding was, Minister and Deputy Jern, that we would debate and vote on the second amendment, and the consequence would be, as you look at the notes in relation to what you described, Deputy Jern, as Amendment B2, that the majority of that would fall away if parts 2, 3, 7 and 11 of the second amendment were adopted. Only part 2 of that fourth amendment would then be debated.
Yeah. Yes, sir, and that's why, because from the reading of the running order, it was seen that Amendment 2 would be voted on block. I wanted to propose that we then didn't vote it on block, but to take out that particular point within Amendment 2 so that we could debate it so that the scrutiny could have a chance to actually talk to members about their Amendment B2 within that process, because if members support Amendment 2, our Amendment B2 falls away automatically and doesn't get
Well, it
to get
does.
voted on.
That's the way that the running order has been.
Yes, but I was advised that we could break up Amendment 2 and vote on separately, so that I was requesting as a member that I believe we've done that before, and I think under population, I believe.
Yes, and this is quite a complicated set of amendments, and well, Minister, it's really up to you what you propose in terms of your second amendment. We were expecting you to propose it en bloc and it to be voted upon on that basis. If you want to take a different course, then we need to be clear as to what that is.
So would it be better for me to propose the first part of this and debate that, which I promise members is a really simple matter, and then do the parts that scrutiny are asking for, propose those at that point? There are, I think, connected amendments later that mean we wouldn't be wrecking the debate if whichever resolution we came to on that particular part, we wouldn't be faced with the Frankenstein law either way on that.
So you would simply be debating the changes to Article 6 only?
Yes.
That's a very narrow matter would be amending. That would be simply the first paragraph of your amendment, because one of the amendments to Article 6. Do you follow? Part 1 is simply, as we see from the running order, clarifying where further fixed terms are allowed in certain circumstances. It'd be a very small debate.
I believe so, sir.
So then you move on to parts 2 to 11 onwards and give scrutiny the opportunity to amend those. Is that what you propose?
So should I just propose them en bloc and we can do different votes on that when it comes to it?
You could propose them en bloc and then have different votes as we go along and give the opportunity for scrutiny to move any amendments as they wish. That might be the best solution. All right, so you're going to propose the second amendment en bloc, and then we'll have separate votes on the various parts and give scrutiny the opportunity to make its amendment B2. Is that what you propose to do, Minister?
So if that works?
Yes. We'll soon find out, won't we?
Indeed we will. At least it's all simple from this point onwards.
Let's hope so. Yes.
And I do mean that. I mean, it will be difficult to follow some of this, but in terms of the issues that are actually being addressed, I do think that this point gets a little bit more simple from this point. So I do thank members for their indulgence on this. Part 1 of the second amendment is something that I hope will be uncontroversial. This amendment was lodged following some feedback from the Jersey Farmers Union. This was a group that I was keen to engage with as we were putting the law together and explaining to them what that might specifically mean for those in that area who are often providing accommodation as well as employment. They indicated to us that they would appreciate greater clarity on the matter of fixed-term tenancies not being able to be followed by a subsequent fixed term. The intention of the draft law is to require fixed-term tenancies to convert into periodic tenancies at their end if both parties wish to continue, and it wouldn't be possible to follow a fixed term with an immediate second fixed term But then that raised the question as what counts as immediate, and that was raised in the context of seasonal workers who may live and work in Jersey for a period of time, leave for a bit, and then come back basically on the same arrangement as before, including potentially in the same accommodation. And if there was a gap of only a few months, would that be considered getting around that prohibition on immediate use of a second fixed-term tenancy? So my view is that in the drafting of the original law, it would have been regarded as a brand new tenancy entirely, and so there wouldn't be a prohibition on employer landlords providing that for their seasonal workers. But following that feedback from the Jersey Farmers Union, there was absolutely no harm at all whatsoever in extra clarifying that in the wording to give them peace of mind and just let them know that they can be sure that they were doing the right thing. So I was very happy to alter the wording slightly just to remove any space for doubt. So that's part one. Hopefully that's okay. The second part of this refers to parts 2, 3, 7 and 11. Again, I was hoping that would be uncontroversial. This part of the amendment ensures that in circumstances where an initial fixed-term tenancy is to end early, that there must be requirements set out in the contract to be met so that the default isn't just the minimum notice. So that's getting out break clauses, etc. there, so that there would be clear terms in the contract for that rather than just presuming what would otherwise be the minimum. And it also gives the court the ability to amend an agreement to put that in if necessary, if that's not there. And let's hope I'm moving on to the correct part of my notes next. Parts 4 and 5 in the second amendment. This amendment arises from a technicality discovered just after P24 was lodged, where it might have been possible for a worker to be thrown out of their home at short notice because of an arrangement where they were directly employed by an agency, but not directly by the business that they were technically working at, but had accommodation provided for. So there is a notice period for tenancy connected to employment ending, and that's a 7-day one, so that's obviously quick. The reason it can be quick is because you would also be factoring the notice for the employment ending into that. So you say they're not going to be employed and that notice is whatever it is, plus 7 days then to lose the accommodation beyond that. But there was theoretically a loophole if your place you were working for was not directly who you were employed by because it was through an agency, etc. So you could have had just a 7-day notice then, which there would be many instances where that would be unfair. So the correction was provided there just to make sure that that was taken care of. Part 6 relates to a tenant's work permit expiring, and it's just a technical amendment to revert to neutral language, more accurately reflecting the practice of employers, of the employers being the applicants for the work permits. And so if I'm going on to parts 9 of the second amendment, this is, again, a minor amendment that loosens up some of the restrictions that I had originally proposed to be in place on the membership of the Rent Tribunal. There were particular people who would be barred from serving on the Rent Tribunal based on offices that they had previously held. On reflection, that was a bit too stingy, and there were actually people who would have held those offices where upon reflection, I thought there wasn't much grounds for giving them a lifetime bar from serving on the Rent Tribunal, when in reality, after a bit of time, they wouldn't be conflicted, and that would be totally fine there. And the final parts, part 10, corrects a referencing error for secondary legislation, because it was identified that the purpose of Article 13H5B was to allow the Royal Court to make rules of court specifying that the Royal Court's procedures for appeals to it from the Rent Tribunal, the reference to and an order made under Article 23 to LE or LF is actually not required, because it's about the Rent Tribunal's procedure for decision making, which is separate to the procedure for appeals to the Royal Court, and therefore amendments proposed to Article 13H5B to reference only Part 4A, in case you're all following, and that makes perfect sense But that covers all of the bits in the second amendment, which I hope are recognised as being mostly editorial in nature and hopefully not too controversial.
So is the amendment seconded?
Yes, sir.
So as I understand it, Minister, are you now wishing to have a vote perhaps on the first, or a debate, then a vote on the very first part, and then we have the amendment from the panel to parts 2, 3, 7 and 11? No? No? Oh, I thought that was the solution.
I thought the panel's amendment was to another article. That's right, yeah.
No, the amendment is to parts 2, 3, 7 and 11 of this amendment, isn't it, Deputy Chairman?
Yes, sir. I'm not proposing that we debate Amendment B2. What I'm asking is that we vote on separately parts 2, 3, 7 and 11 of the
I see, that's all you're proposing.
amendment, because it is related to our amendment, and our amendment covers that point plus extra. So
I see.
I was
That's
wanting
fine.
for us to cover it at this point.
That's fine. Thank you very much. Does anyone wish to speak on this second amendment? Yes, Deputy Chairman.
Yes, and I hope, and I apologise to members if this comes as a surprise, but scrutiny, first of all, to the Minister's second amendments. I mean, many of it is absolutely administrative, as the Minister points out, and also a lot of it has come from the scrutiny work, and during the scrutiny work, and what the feedback that we got from different organisations and landlords, the Minister rightly read those and made the amendments accordingly during as the process went on. However, I wanted to focus and just take a vote separately, so that's all I'm asking to do, yes, on the specific parts around 2, 3, 7 and 11, which all focuses on ending an initial fixed term early without reason. And why I'm asking this is because if we vote for the second amendment now, this particular bit, the scrutiny's amendment B2 falls away, and scrutiny doesn't have a chance to present what our findings are within this particular area around ending an initial fixed term early without reason. And so therefore I wanted a moment to be able to talk to you about that, and for members to then be able to vote on that particular point now, rather than us not being able to have that discussion at this particular point. So the Minister's amendment adjusts the drafting of Articles 6B, 2E and 6DB so that tenancy agreements must always set out one or more requirements before either party can end a fixed term early. So that's about break clauses within a fixed term. There now is the ability to, within a fixed term, a landlord or a tenant will be able to ask for that fixed term to be stopped, given a 3-month notice or a 1-month notice. What the Minister is asking with this amendment is to require one or more requirements that is written within a contract to be done before either party can end that fixed term early. And the panel does support these intentions, and we questioned at the beginning why the Minister in his initial amendments to the law didn't provide this safeguard in his first proposal of the draft amendment law, because at that time the original proposed law at the moment was then a fixed term could be finished at any moment with 3 months or 1 month notice, which as Deputy Curtis, who unfortunately, as he explained, is no longer able to contribute due to other commitments, he rightly said that the panel was worried that actually this specifically would mean that tenants especially, but also landlords, fixed terms aren't fixed terms anymore. There isn't a fixed term. If you within a fixed term can then stop it at any point without a reason for 3 months or 1 month notice, even if it's only one time up to 3 years, only one initial contract, within that time, as the draft law, as it originally was proposed, meant that you could stop it, that fixed term contract 3 months or 1 month at any time without any reason, given reason. And so it's a surprise that, and I just wanted to put that there because it shows that all the discussions that we've had already, it shows that the minister, in a sense, was being very, I think, very supportive to landlords, especially to be able to show that there was a way to not be bound by a contract potentially that could be up to 3 years long, and so it gave that flexibility. But actually, from a scrutiny perspective, we felt that was a concern for a tenant, but also for a landlord. So we were supportive of the minister putting in these provisions that he has talked about in his second amendment about requiring one or more elements within a break clause section of the contract that either party has to fulfill before breaking that contract early. But we felt that it wasn't enough. We felt that on top of that, we wanted to also feel that there could, because we've talked about that landlord-tenant imbalance of power that we have seen and the evidence that we have collected as scrutiny, we felt that we would like to propose an additional amendment to that, and that we would then ask to, our amendment addresses a real and recognised problem. So there is persistence at the moment of one-sided break clauses that just disproportionately favour landlords and undermines that security that the draft amendment law seeks to provide. And that's what I wanted to discuss with the Assembly now. And so therefore, Amendment B2 tries to does the same thing as what the minister is proposing, so that it still keeps the amendment that the minister is proposing under the second amendment. It doesn't get rid of that, so it holds what is the space that is now and what the minister is proposing, but it adds an extra safeguard that we believe is missing in the minister's text. Because during the panel's review, the minister himself acknowledged that one-sided break clauses are an issue. The Law Society of Jersey went further, stating that mutuality in break clauses is both reasonable and necessary. So we even, were encouraged to look into this aspect by the Law Society of Jersey. Yet under the minister's amendment that he is proposing now in the second amendment, unilateral break clauses will still be permitted, so long as the statutory minima are met, which means, as drafted, the law would permit break clauses that favour one party over the other. And as we've heard, and as say Deputy Curtis talked before he left the chamber about that power imbalance that we're still seeing within the tenant-landlord discussions, especially when a contract is being discussed. And so our amendment ensures that those break clauses must operate equally for both landlord and tenant. That principles of fairness is the heart of this approach. And because, as I said, if members approve the minister's provisions in parts 2, 3, 7 and 11. And as I said, the scrutiny does support that change. We do support that amendments, but we are trying to add an extra balance on top of that. And because our amendment would fall away, if this amendment is agreed, then I wanted us to vote on this particular aspect of Amendment 2 now, so that we could then also go on to the, if that's rejected, we can then talk about the scrutiny panel's B2 amendment, which talks about this inequality break clause, and then focuses in on being able to show that we need this proportionality and safeguard that the panel feels that is needed in break clauses. I hope that makes sense to members. I've tried to hopefully be as clear as I can.
Thank you, Deputy. Deputy Scott.
Yes, I just wondered if I could ask the chair of the scrutiny panel point of clarification, please. So perhaps she might inform members how that works in terms of when you talk about mutuality of break clauses and the opportunity to exercise them, and are actually aligning that with the unequal kind of basis on which rights are given to terminate because reasons differ. How does that kind of tie together, and in terms of whether one actually restricts the other?
Deputy Joan, can you deal with that? Do you wish to deal with that?
And I'm not quite sure what the Deputy Scott is referring to. What we have, of course, said that's at the end of the day, and it speaks to the Minister's comments on our B2, is that that we believe that if this contract does not show that there is, or that if one of the parties or other parties believes that it is unfair and there is not this balance within the break clauses, the Petty Debts Court is the place to say that. And as I say, the Minister has already alluded to the fact that Petty Debts Court is a place that to go to add break clauses to. So.
Deputy Howell.
Sir,
Thank you, sir.
could I make a point of order before?
Oh, yeah.
Yes.
So I'm very sorry to do this given the complexity, but could I just clarify, if the part of the amendment that we're talking about here is rejected, as the scrutiny panel have asked,
Yes.
and then we reject when we come to discuss the amendment from scrutiny, if that amendment is also rejected, where does that leave us? Does that leave us without either of the provisions, basically?
Yes, it leaves you without those two sets of amendments.
So in that sense, the vote on whether or not to reject this part of the amendment is also a vote on the amendment.
Yes, it is, yes.
B2, yes.
Yes, absolutely, yes. Yes, Deputy Howell.
Thank you, sir. I was just wondering if the deputy of the head of the chair of the scrutiny panel may be able to explain how these break clauses are going to work in with an actual contract that a landlord and a tenant both sign. Thank you, sir.
Point of clarification, accepting that, Deputy Jones?
Yes, I think there are break clauses that happen now within the currently, so there are within fixed term contracts, there are already break clauses that are being put in if a landlord and a tenant agrees to that. What I believe that the Minister with his second amendment is trying to put in is that becomes a de facto, that there needs to be break clauses, so that if you want to stop your fixed term contract, giving 3 months or 1 month notice, that there has to be break clause within that. So that's the Minister, but that's for the Minister to defend. Where the scrutiny panel would like to add an additional to that, because we support that, we think that that's an important part of having a break clause, is that we need to have that equality within the break clauses, because it could be one-sided. So a landlord could demand a certain amount of break clauses for a certain amount of requirements that a tenant has to adhere to before they can break a fixed term agreement, like finding a new tenant to take over the contract, or other aspects, or pay their TV licence to the end of the year, or etc. There are many aspects, but it may not be balanced equally with what the landlord is required to do. So our request was to try to show that there is more equality in that break clause.
So, can I just...
Ward?
I apologise for asking for a clarification, but I don't understand why, if it's an amendment that adds to something, we can't vote on this amendment as is and then come to that second amendment to see whether you want to add to it. I don't see why they're mutually exclusive. It's an amendment to certain parts. We could vote for those parts and then amend them later, I thought.
Yes,
that's what we were doing.
These amendments need to be rejected for the scrutiny's amendments to be debated. That's the point.
Sorry, I didn't understand why it was, but I'll just take your word for it because I have no other way of doing this. Thanks.
Yes. Deputy Scott, is it a point of clarification, or do you want to speak?
It's a point of clarification, because perhaps in order to... Sorry, I can see a conversation's going on, and I was going to ask another question of the chair of the scrutiny panel that helped me just understand this. She said that the Law Society supported the mutuality of break clauses. Was this in conjunction with supporting the reasoned grounds for termination? Because I just have difficulty in terms of squaring up the mutuality and lack of mutuality. Thank you.
So, This is related to fixed term, and so the fixed term, in a fixed term, you do not need to give a reason for giving notice. And so it's under Article 6D, I believe, of the amendments that the Minister has provided, is that at any time a landlord or tenant within a fixed term contract, or the proposed fixed term contract, will be able to give notice if they give 3 months or 1 month. I believe that the Minister has tried to add extra safeguards within that by adding that there has to be some kind of break clause added to the contract to be able to give notice, but without a reason. Where the scrutiny panel is adding an extra to that, another layer, is that those reasons in the contract, when they're negotiating the contract, that the tenant and landlords, those break clauses are equal in the sense that there is not the power imbalance, because we have found evidence that there are one-sided break clauses are an issue. The Minister has identified it, the Law Society identified it as well, and they believe that it's reasonable and necessary. So that is basically the thing. It's adding to what the Minister is proposing. It's not trying to take away. But because of this, and I agree with Deputy Rob Ward, because of the way it is set out, the order, it meant that our amendment B2, which adds to the Minister's amendment, would fall away, and so we would not be able to discuss our addition to that. And I felt that was that was a missed opportunity, and something that I felt that was really needed, because it's something that scrutiny did find, and we have evidence to prove it. So,
Deputy Howe, your light's still on.
Yes.
Your hands on your head.
Could I ask a clarification of the Attorney General, please, sir?
What particular
Well, I was just
issue?
wondering, it's the issue of the contract, because we all understand at the moment that if you have a year contract, it's a year contract. If you have a 3-year contract, it's a 3-year contract. But if we have these break clauses, they won't be 1-year contracts or 3-year contracts. That's what's puzzling me, sir. And I wondered if it's because of the break clauses, and I wonder if the Attorney General may be able to help me, sir. Thank you.
Attorney General.
Sir, as I understand it, we are in the territory of how a tenancy, which is an initial term tenancy, so it's for a fixed period as an initial term, how that is ended. And the Minister's amendment originally in Article 6D, 6D little b, included some words in brackets, if any, about the requirements to give notice. And that was felt that, as I understand it from scrutiny, that opened up a possible loophole in that there may not be any requirements in the tenancy agreement about how notice is given. So there are two possible solutions to that. And scrutiny has proposed that there should be mutuality of requirements in a tenancy agreement, so that both landlord and tenant effectively have to have mutually fair provisions concerning giving notice. So that's the first solution. And then the second solution is as proposed by the Minister, whereby he is deleting the words in brackets, if any, from his Article 6D, and he is proposing an amendment to Schedule 1 of the current law about what a tenancy agreement must specify, and he is proposing some additional language at paragraph 12 to Schedule 1, and an additional example about how a tenancy agreement might cover giving notice. Although I haven't been asked the question directly by Deputy Howe, I will give my view anyway. I have to say that I think the Minister's solution is the preferable solution in that it provides for more certainty.
Does anyone want to volunteer that was those in the public gallery? Please turn your phone off. Keep it switched off. Yes.
As I was saying, sir, I think the Minister's solution provides more certainty for both landlords and tenants, because where there is a requirement to judge fairness, that is an area of subjectivity that may encourage people to end up in the Petty Debts Court because they can't agree on what is fair. So my view was that the scrutiny panel's amendment delivered less certainty in terms of protections to that of the Minister. So that my advice to the Assembly is that the Minister's solution, while I appreciate the concern of the scrutiny panel, but the Minister's solution delivers more certainty to landlords and tenants because it removes this requirement of mutual fairness, which parties may have very different views about and may only encourage people to end up in court where they didn't need to be there in the first place. Thank you, sir.
Deputy Gardner. Oh, Deputy Howell?
Can I just clarify then? If you've got a break clause of 3 months, effectively the lease is only 3 months.
No, the tenancy agreement could be for an initial term of 2 or 3 years, but it may provide for a break clause at a certain point, but it needs to set that out in the agreement. It needs to say when that break clause is exercisable and who it is to be exercised by. So it is including requirements in the tenancy agreement about how notice is given and when it is to be given.
Deputy Gardner.
So I would like to have order explanation, because I hear what Deputy Rob Ward said, and the order, can we change the order so we can vote on the Minister, what Minister proposing, and if somebody would like to change or amend according to the scrutiny, so scrutiny not deleting it, scrutiny adding. So I'm just checking, and when Deputy Rob Ward stood up, I said, actually, is it our decision how the order can go? Because it does sound there are 2 options, and 2 options are not deleting each other. It just
We're now debating the Second Amendment, and there'll be separate votes on the relevant paragraphs of the Second Amendment. Yes, so the position is, if you look at the running order document, that the majority of the scrutiny amendments under what they call Amendment B2 will fall away if the Minister's Second Amendment is adopted in its entirety. But in fact, as you see from the text at the bottom of page 3, even if the amendments are adopted in their entirety, Part 2.2 of the scrutiny amendment will remain to be debated. And although it's a matter really for Deputy General to explain to the Assembly, my reading of Part 2.2 of the scrutiny amendment is it does deal with this particular issue. It deals with the land, well, 2.2 says that in Article 6, new Part 3, after new Article 6, big D, small b, insert as paragraph 2. However, if the requirements purportedly set out in the agreement under paragraph 12 of Schedule 1 are more favourable to the landlord than the tenant, A, the landlord cannot end the initial term early under this article, but B, the tenant can end the initial term early under this article as long as they satisfy those requirements that apply to the tenant. So even if the amendments are adopted in their entirety, that provision will remain to be debated under the scrutiny amendment. Anyone wish to speak on the Minister's second amendment? Deputy Stevenson.
Thank you, sir. And it's a question to the Minister, really, rather than a speech. But given all that's just been discussed, in his summing up, I would quite like, if possible, to hear some indication about why he doesn't support the scrutiny amendment. And then I understand that there is, he himself has an amendment to that amendment. And I appreciate that we need to focus on the debate before us here today, but we've just heard quite considerable evidence that perhaps we need to just stray slightly today. I'd appreciate a bit of clarity on that. Thank you, sir.
Does anyone else want to speak on the second amendment? I call upon the Minister to reply. Minister.
Thank you, sir. Well, not a word was said about all the other parts of the Second Amendment, so I'm hoping that that's evidence that those are uncontroversial. So I can dwell just on that second part, and I'm grateful for the intervention from the Attorney General. The Chair of the Scrutiny Panel is absolutely right to highlight this issue. There is a gap in our current framework in the residential tenancy law where it is possible for a fixed-term tenancy to be offered. That includes biased and one-sided break clauses that are totally swayed towards the landlord who's offering the tenancy above that of the tenant. I've seen these myself in the work I've been doing to prepare for this. I saw an example, just one that sticks out very clearly in my mind, of a tenant who was asked to sign a one-year fixed-term tenancy. It had its start date and its end date, very clear, but there was a break clause in it that said that the landlord could, at any time in that fixed term, issue 3 months' notice for that tenant to go, and there was no reciprocal clause for the tenant to be able to go. So that was really bad security of tenure there. It purported to be a fixed-term tenancy, but there was a completely one-sided and unfair break clause in that, and the break clause didn't specify any terms that would have to be met before that break clause could be used. It could just be used whenever, and that's obviously totally unfair and something to be resolved, which the scrutiny panel is right to look at that. So in reflecting on what we had drafted and lodged in the aftermath of that, when we're still going over some of these issues, we came up with this second amendment that addresses quite a few issues in that, including this subject, where it adds into it an element that says that for these break clauses, there must be requirements set out in the contract to be met, so that the default isn't just we can issue notice whenever in a fixed term. Because if you've signed up to a fixed term, you are expecting a degree of certainty from that, but those kind of clauses totally undermine that and take that away. So the Attorney General has suggested that the way of dealing with this is done more cleanly in the amendment that we're debating now, which is why it's my preference that the Assembly sticks with that wording, and the Attorney General's intervention was helpful in that regard, and I hope that's okay with members. And I hope this is getting at Deputy Stevenson's question, is that if the Assembly declines to do that, we will come back a little bit later for subsequent amendments, because scrutiny have an amendment with a package of amendments in that, and one of those deals with this same subject as well. My view was that their wording was not as good as the wording we were looking at, and though it's well-intentioned, it sticks too much on the lines of equality rather than equity, and doesn't take into account where exactly equal terms of break clauses might actually not be appropriate in some circumstances, especially when there are the grounds that the landlord can use to end a tenancy early in the new Article 6 of the law that they don't need to have in the contracts because they're already in the law and they can use them. So even if a break clause technically had equal terms, there wouldn't be equality because the landlord has extra rights provided for in Article 6. So my amendment to their amendment was to stick to this arrangement where the terms of those break clauses have to be set out in the contract, and there has to be a point at which they can be initiated rather than just initiated for no reason at any time at all. I hadn't been aware of this before the debate started, but the chair indicated to me that if we got to that point, she'd accept my amendment to it. So, trying to be crystal clear now, my preference is we go ahead with the wording that I've got now. If the Assembly disagrees with me on that, we have the backstop then of debating the scrutiny panel's amendment, which they are indicating they would support my amendment to it. As a backstop, that will do really well, and that will be okay. But if we did end up in the situation of rejecting both, then there'd be no progress at all on this subject. So plan A, stick with this amendment. Plan B, go to the one with the scrutiny panel and I having amended each other. And that, I hope that makes sense. And I think I'm expecting a clarification.
Yes, Deputy Gardner.
A point of clarification, if Minister can indicate. Plan A, does it mean that during the fixed term that landlord needs to give 3 months notice?
They would have to be a point at which, yes, but not for any reason at any time. They would have to say something like, if it's a 3-year fixed term, they would have to say something like, and this becomes available after the first year. They couldn't say it becomes available on day 1, for example. There would have to be a condition that must be met before that could be used, rather than the current situation, which is you can have bias break clauses with no preconditions to be met. So that's where the safeguard comes in there. And I call for the appel. I'm happy to vote on the first part.
Yes, I think we'll do the first part first, and then parts 2, 3, 7 and 11, and then the balance of the parts. So the appel is being called for. Members are invited to return to their seats. We are voting on the Minister's second amendment, and we're voting on the first part of that amendment, which deals with Article 6 of the law. I invite the greffier to open the voting. Four members. Four members have had the chance of casting their votes. I ask the greffier to close the voting. And I can announce that part 1 of the amendment has been adopted. 36 votes for, 5 votes contra. Yes.
Those voting contre, the Connotabs of St Bralard and Trinity, Deputies Balash, Ferry and Wilson.
I'll move to parts 2, 3, 7 and 11 of the amendment, which scrutiny have asked the Minister to take separately. I ask the greffier to open the voting.
Sorry, sir, can I just, to clarify, because there was a number of rulings that you made just earlier on a number of areas, is that if this part, which we've called on to vote separately, if it's contra, it will go to B2, to Amendment B2 as a whole. But if it is passed, we will only go to one section of B2. I think two.
Yes, if parts 2, 3, 7 and 11, most of your Amendment B2 will not be debated. only part 2(2). If it's rejected, then the whole of your amendment to these parts will be debated. Invite the greffier to close the voting.
All the lights are coming up all together. All right, hang on. Shall I reset and we start again?
I think we should.
Let's go right back to the beginning.
Sir, I can't vote.
No, because I've turned it
I think there's been a problem. We're going to
start again.
run the votes on parts 2, 3, 7 and 11 of the Second Amendment again. Invite members to return to their seats. I'd like the greffier, when appropriate, to open the voting. Voting is open. If all members have the chance of casting their votes, I ask the greffier to close the voting. Those parts have been adopted. 27 votes pour, 17 votes contre. Minister, do you wish to propose the balance of the parts en bloc, parts 4, 5, 8, 6, 9 and 10?
So I had earlier spoken to those articles. I apologise if that was the wrong time to do it. Otherwise, I was expecting to just call the appel.
Forgive me, I said, perhaps I said the wrong thing then. You wanting the Assembly to now vote on those ones together?
All of them together, if
Yes.
members are happy with that. Thank you, sir.
So votes on 4, 5, 8, 6, 9 and 10, the balance of the Second Amendment lodged by the Minister. Invite members to return to their seats and invite the greffier to open the voting on the balance of the parts. All members have the opportunity of casting their votes. I ask the greffier to close the voting. The balance of the parts have been adopted. 36 votes for, 8 votes contre. Yes, the 8.
Those voting contre, the Connétable of Grouville and deputies Balash, Rose Binet, Howell, Tom Binet, Ferry, Barbara Ward and Wilson.
Now move on to the scrutiny amendments, at least the first part of them, which will be taken in separate parts in accordance with the running order. They'll be proposed by the chair of the Environment, Housing and Infrastructure Scrutiny Panel. And I will be inviting the greffier to read the relevant parts of the amendments. So, greffier, this is the 4th amendment, and the Assembly will be dealing with part 2(2) of the 4th amendment. Yes.
Article 6. 1. In Article 6, new Part 3, for new Article 6D. Oh, sorry, no, it's Part B22. Sorry. In Article 6, new Part 3, after new Article 6DB, insert as paragraph 2. However, if the requirements purportedly set out in the agreement under paragraph 12 of Schedule 1 are more favourable to the landlord than the tenant, A, the landlord cannot end the initial term early under this article, but B, the tenant can end the initial term early under this article as long as they satisfy those requirements that apply to the tenant.
Deputy Chair.
Thank you, sir, and thank the Assembly for for going through that earlier, but I did want to highlight this issue about fixed term agreements, both what is happening now, so it's very clear that there is this the concerns and potentially one-sided break clauses that potentially happen already, but what we could potentially go for, and the fact that we have found evidence that there needs to be this more fairness and balance. But because the Minister's second amendment has been accepted, and as I had said, the panel supported that, we were just adding to it. And this leaves only part 2.2 of Amendment B2. We feel as a panel that on its own it is redundant because the panel was asking, because part 1 and 2 of the panel's amendment was requiring tenancy agreements to set out the conditions for ending a tenancy early, and these have already been taken up with the Minister. What was missing is the safeguard that those conditions cannot favour landlords over a tenant. But part 2 was written to enforce that safeguard, but without having what we wrote, we have put to part 1 and 2 in our amendment. The wording of part 2.2 is not attached to anything. It's not attached even to what the Minister has amended now. And so I feel that this amendment as it stands just purely on B2.2 of Amendment B2 is therefore in a way redundant, and I would ask the Assembly to reject it, or we withdraw it. I'm not sure the correct way, but we feel that as it stands now it doesn't sit correctly. And if we withdraw it.
So you want to withdraw the amendment?
Yeah. Yes, sir.
Thank you very much. In that case, move on to the next amendment.
Do we need to vote on that, or is it just...
I think the debate hasn't begun on the amendment, so I think the Deputy is entitled to withdraw it. It wasn't seconded. So the next matter is Amendment B3, which is dealt with in your helpful report at page 8, Deputy Chairman. And that is the amendment to part 3 of your amendment. And again, I invite the greffier to read the amendment. You can have mine if you want, greffier. Yes.
In Article 6, new Part 3, for new Article 6E, substitute 6E, how landlord or tenant ends tenancy by notice without reason during periodic tenancy. A periodic tenancy may be ended without giving a reason by A, the landlord giving the tenant at least 1 year's written notice, or B, the tenant giving the landlord at least 1 month's written notice.
Yes, Deputy.
Yes, so thank you, and I hope that this can be brief because the Minister has accepted this amendment B3, and I hope that also shows that not only the Minister but scrutiny also is proposing this, that this is the way forward. It is something that has already been referred to. It is the no reason notice for landlords to have 12 months no reason notice. And so while the panel understands the intent by the Minister to remove the ability of landlords to end periodic tenancies without reason, we believe a complete removal is unnecessary and potentially counterproductive. And as the proposed amendment law now provides a list of reasons that give 7 days to 6 month notice for periodic contracts, the panel felt that as the policy intent was about tenant security and landlord transparency to help landlords gain back their property, then we felt that a no reason notice with a long lead-in time was a balanced addition to this list. This long lead-in time protects tenants while giving landlords a fair and transparent path to regain possession in non-urgent scenarios. It avoids the misuse of statutory grounds, which we have tested, and we are when we were doing our scrutiny, and supports honest intentions. We believe it's a balanced solution that promotes trust and stability, and therefore we welcome that the Minister has accepted our amendment, and we hope that the Assembly will do that as well.
Thank you, Deputy. Is the amendment seconded?
I do.
Does anyone wish to speak on the amendment? Minister.
Thank you, sir. Again, to thank the scrutiny panel for this amendment. When it was first put on the table, I'm sure they would have been amused to see my reaction, as I was initially very, very reticent when looking at it. But once I considered it properly and carefully, I began to become of the view that there was real merit in this, and then had conversations with various states members along the way, and found that there was a desire from some members to have this extra backstop put in the law that can hopefully be advantageous and cover off some instances where there would be confusion about the current regime that I'm proposing for reasons for notice. So initially I was a bit wary of a suggestion of a no reasons grounds, because that is a big part of what I've been trying to overcome with this, where if a tenant is being asked to leave their home, that there ought to be a reason for it, and those with illegitimate reasons, like revenge or retaliation for a landlord, for a tenant seeking to uphold their legal rights, should not be on that. But what the scrutiny panel is proposing is, I think, very balanced and probably captures the best of both worlds there, in that this will, because it's a 12-month notice period, anyone who did want to use it to exact revenge against a tenant for not behaving themselves in their view, would have to be pretty patient to wait 12 months for it, and let's face it, that ain't going to happen. That's pretty unreasonable. But at the same time, it provides a backstop for perhaps rare cases or circumstances that might arise where the reasons that are provided for in the proposed Article 6 of the law aren't already accommodated. So if you as a landlord decide that you want to sell your property, the Article 6 in the proposed residential tenancy law amendment perfectly covers you already. So if you want to renovate it, if you want to move into it yourself, if you want a close family member to move into it, a carer to move into it, you are already perfectly accommodated for in the draft residential tenancy law amendment. And in those situations where there is a big problem, like the tenant seriously breaching their agreement or causing a persistent serious nuisance, etc., there are now quicker grounds provided for in that Article 6. The 12-month no reason grounds is in addition to that, not replacing it. So in a circumstance where a landlord felt that the grounds were catered for in the draft amendment law, they could use those. But if they had perhaps a longer term ambition or something they wanted to consider, they will still have this backstop available to them with a long lead-in time. So the kind of circumstance I can think of where that might be helpful would be if you were somebody who owned a rental apartment that was so closely connected to your home you could describe it as being part of the same building or same facility, etc. And you were getting to a point in your life where you simply didn't want to be a landlord anymore. You might just not want the hassle anymore. You might be getting older, but because of the way that property is situated against your own property, it's not completely independent. So if you're planning for that, you know in advance that's something you want to do. You can use this grounds to enable you to get control of that property back without having to sell it, which you might not want to do because you might not want strangers that you have no contractual relationship with in that property that's so closely connected to yours, or to try to meet one of the grounds that's already in the law. So this will not require any reason for that, and can hopefully cater for those rather unique situations that might not have been catered for otherwise. So I thank the panel for proposing that and thank the members who spoke to me outside of this debate to indicate their support for it, and hopefully it will command the Assembly's support as well.
Thank you, Minister. Does any other member speak on this amendment? I call upon Deputy Jones to reply. Deputy Jones.
Thanks. I'll be very quick, and just to reiterate that the Minister says this is an addition to the list. It's not a change to the list. This is an addition to the list of reasons. And as was said, it is this stopgap. It adds it on because we heard, especially from landlords, that this was something that they felt was needed to be able to get their properties back when there were situations where they couldn't on the list that was already proposed. That list is much shorter periods of notice periods. This is one. It is a year when we felt that that was right in the circumstances. So I will close there and call for the appel.
The appel has been called for. Members are invited to return to their seats. I invite the greffier to open the voting. All members have the chance to cast their votes. I ask the greffier to close the voting. Announce the amendment has been adopted. 35 votes for, 6 votes contre. Yes.
Voting contre, the Connétable of St Clement, and Deputies Balash, Ferry, Barbara Ward, Wilson and Andrews.
The Chair of the Environment, Housing and Infrastructure Screening Panel will now propose Part 4 of the 4th Amendment. I invite the greffier to read the amendment.
In Article 6, new Part 3, new Article 6F1, rows A to D of the table, for not allowed, substitute not applicable.
Deputy Jones.
Thank you, sir. And again, the Minister has accepted this, but we will still be discussing it now. And just to inform the Assembly, this is a technical amendment, but the scrutiny panel felt it was an important one because the statutory table of grounds of notice that currently, if you see under 6F, currently uses the term not allowed for certain grounds during the initial fixed term. So this, we felt, implies prohibition, when in fact these grounds are simply inapplicable. Article 6D amendment states that either party, and we've just talked about it in Amendment 2, is that either party, landlord or tenant, can end an initial fixed term tenancy without a stated reason, provided notice periods the notice periods that are there, 3 months and 1 month, and the contractual requirements are met. So those are the break clauses that we have just been talking about. This is similar to what happens now with periodic tenancies under the current 2011 law. What the panel concluded was that the Minister's current proposal, if the landlord gave notice to a tenant during a fixed term contract and inadvertently explained that they were doing so due to one of the reasons listed in Article 6F, such as because they would want to sell their property, or they're doing a substantial renovation, or a family member wanting to use it, or a landlord's helper, then this could be interpreted under the proposed law as not allowed, and it could cause concern. Yet if the landlord followed Article 6D and gave no reason at all for that notice on a fixed-term contract, then they would be following the law. So our amendment replaces not allowed with not applicable so that it improves legal clarity and avoids misinterpretation. So it ensures the legislation reflects its true intent. And I hope that's made sense from a technical perspective.
Thank you, Deputy. Does any member speak on this amendment? Minister.
Thank you, sir. Just very briefly to say that I'm more than happy to accept this amendment, and using the alternative words that the panel has provided helps provide greater clarity for what we were seeking to do. So I'm grateful for them for bringing it forward.
Thank you, Minister. Does any other member speak on this amendment? I call upon Deputy Jones to reply. Deputy Jones.
I think it's quite simple, and so therefore I call for the appel. So.
It has been called. 4 members are invited to return to their seats. Ask the greffier I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the amendment has been adopted. 37 votes for, 3 votes contre.
Those voting contre, Deputy Balash, Ferry and Barbara Ward.
The Fifth Amendment is proposed by the Minister for Housing, and I invite the greffier to read the amendment.
Part 1, Article 6. 1. In Article 6, new Part 3, for new Article 6G2, N, substitute N, tenant's illegality or nuisance, meaning that 1. The tenant has used or caused or permitted the use of the residential unit for illegal purposes, or 2. Both A. The tenant has caused or permitted a repeated or serious nuisance in the residential unit, or repeated or serious interference with the reasonable peace, comfort or privacy of a neighbour of the residential unit, and B, the landlord has given written notice under paragraph 3 that the tenant has not corrected the nuisance or interference as requested by the notice. And 2, in Article 6, new Part 3, for new Article 6G3, substitute 3, a landlord's written notice under this paragraph must do one or both of the following and request the tenant to correct the breach, nuisance or interference in that way, but everything requested by the notice must be reasonable. A, specify conduct that the tenant is to stop immediately, or B, specify action that the tenant is to take within a specified period of at least 7 days after receiving the notice. Article 14, in Article 14.4, for the new Article 15.2G, substitute G, whether the tenant has caused or permitted a repeated or serious 1, nuisance in the residential unit, or 2, interference with the reasonable peace, comfort or privacy of a neighbour of the residential unit.
Minister.
Thank you, sir. Again, hopefully this one will be okay. This amendment is around the notice provision for a repeated or serious nuisance. This takes into account the feedback since the publication of P24 and the evidence that the scrutiny panel received during their review. It removes the proposed requirement for a police officer or state's employee to attend a home to witness nuisance before a landlord could issue their tenant notice to leave on that ground. Whilst that original provision was well-intentioned, some concerns have been raised about potential overkill and capacity as well. So I think removing that requirement strikes a better balance, and ultimately the Petty Debts Court can have the final say if this comes up. Members may note that this is very similar to an amendment from the scrutiny panel. We were both working on our amendments at the same time, but I'm suggesting that my wording is the one we should opt for because it contains a distinction that there should still be some requirement from a landlord to write to a tenant instructing them to cease their nuisance and giving them a chance to correct their behaviour before jumping straight into issuing them notice. So I think that provides a better balance than what was originally proposed and was done so in response to the evidence that we observed scrutiny receiving on this. So I propose that amendment, sir.
Is the amendment seconded?
Yes, sir.
Thank you. Does any member wish to speak on the Fifth Amendment? Deputy Chair.
Thank you, sir. The scrutiny panel is asking the Assembly to reject this Minister's Fifth Amendment. Like the Minister, we recognise that requiring police or States officer attendance before a landlord can act on serious or repeated nuisance is not workable. The police do not want this role. The housing and nuisance team are already stretched, and officer attendance does nothing in evidential terms. On that point, there is agreement. Where we differ is what replaces it. The Minister has now proposed a written warning system. A landlord must give the tenant written notice, specifically the behaviour to stop or the action to be taken, and to allow for at least 7 days for compliance before serving notice. And this notice would then be for 7 days, as explained in 6F. The problem is that this practice may create more problems than it seeks to solve. Jersey already lacks a comprehensive statutory framework for nuisance. The only statute on the books is the Statutory Nuisance Law 1999, and it's limited in scope and does not cover civil or private nuisances. In fact, this week, the Environment Minister talked about its restrictions on Monday, discussing a specific situation under the Statutory Nuisance Law and the high bar that it sets. And in that context, the panel found that the wording repeated or serious nuisance would already allow landlords to act on single significant incidences. So therefore, that lowers the evidentiary burden that the statutory nuisance law creates, as there is no longer a need to prove a sustained or repeated pattern of behaviour. The panel received the Minister's comments to the scrutiny report recently, I believe on Monday, and we understand that he rejects our finding on this. However, the panel wishes to explain the evidence behind finding 48, if members have the panel's report at hand and well thumbed through. The panel believes that the amendment law lowers the threshold for intervention on nuisances. The 2011 law did not explicitly consider nuisances. This is a new addition. These were instead captured under a breach of contract under Article 12, currently in 2011 law. And breaches of contract could, in theory, include a single serious incident. But the court also had discretion under Article 15 to consider whether breaches were continued or repeated, which acted as a safeguard. And the Minister of Housing is saying that the amendment law does not lower the threshold because single incidences could already be pursued as a serious breach under the 2011 law. However, we heard from the Minister of Environment he confirmed that while this may have been possibly technically currently in 2011 law, in practice his officers did not enforce a single incident under the 2011 law. So though in practice it could potentially happen, there has never been an enforcement under the 2011 law. So by making serious nuisance an explicit statutory ground, the amendment law removes the safeguard around repetition and creates an expectation that landlords and officers will act on a single incident going forward. And now the Minister proposes a system that requires a written notice asking the tenant to correct a nuisance. And while this may seem like a good safeguard against premature or rash notices being served, I believe that there are a number of serious risks that this procedural hoop creates. First, what happens if the nuisance was that single significant incident? How can a tenant correct behaviour that has already happened? The Minister provides no clear answer, and that kind of uncertainty will only invite disputes. And if the nuisance is repeated, the Minister's model risks creating a cycle. A tenant could comply for a short time, then start again. Each time the landlord would be forced to issue a new warning and then restart the process, leaving neighbours living with repeated disruption and landlords powerless to act. What counts as correcting a nuisance can also be highly subjective. A landlord may think the problem is ongoing, a tenant may say they've complied. That invites disputes over whether the written warning has been met, dragging matters out further. The Minister presents this as a high threshold, but in reality it creates a procedural loop that does not resolve the underlying issue. It risks giving both landlords and tenants the impression of protection, while in practice prolonging conflict. And ultimately, it will always fall to the court to decide whether the landlord's evidence is sufficient. We believe that is the proper safeguard here. Adding extra procedural hoops only creates delays and uncertainty without shifting the burden of proof. So I'd like to be clear about what members are being asked to endorse if they support the Minister's amendment. You would be replacing one unworkable safeguard, an officer attendance which does not have to provide evidence. The only point is that the officer has to attend, with another safeguard that risks indirect cycles of warnings and relapse, because now instead it will be a written warning for 7 days, and then after that 7-day notice could be given. But we, as I said, we have not been able to, and of course this amendment came late for proper detailed scrutiny on this, but where we are concerned is that repeated loop of between the tenant and the landlord on complying to a nuisance. What is a nuisance? How is it amended? And that what happens with that single incident, significant incident. You would be placing landlords and tenants into a system where disputes over whether a warning has been complied to, and this is almost inevitable. And you'd also be entrenching a process that prolongs nuisance for neighbours rather than solving it. This is why we are asking you to reject the Minister's Fifth Amendment and instead support the panel's amendment C1. This removes the unworkable requirement for officers' attendance, avoids these new procedural pitfalls, and leaves the proper safeguard where it belongs, with the court. So to repeat for members, we would request that you reject the Minister's Fifth Amendment, and therefore we can discuss Amendment C1 from the of the panel's amendment to be able to see that this is a workable for the future. Thank you.
Thank you, Deputy. Does any other member speak on the Fifth Amendment? In that case, I call upon the Minister to reply. Minister.
Thank you, sir. I thank the chair of the panel for outlining her reasons for the panel taking the stance they do on this. And if it's the case that the Assembly doesn't support this amendment, then there is the backstop of the scrutiny panel's amendment. So again, my preference is to stick with the wording that I'm proposing, but it's that there is still an alternative on the table if that's not to be the case. So members don't need to worry about that too much. But so the reason that we were suggesting that there ought to be this requirement for notice to be given to get the tenant to correct their behaviour comes from the fact that the notice period for this particular grounds is just 7 days. That is not a long time. And so we felt adding that safeguard in would make this provision stronger and hopefully more justifiable on human rights grounds as well, sir. Bearing in mind that there's also a notice in the draft amendment law for ending a tenancy on the basis of serious breach of contract, that is for 1 month. It's a month-long notice period for that, and there is already a requirement proposed in that there should be an attempt from the landlord to write to the tenant to get them to correct their behaviour. So just to me, it just doesn't feel right that you would have that for a month notice period, but not a 7-day notice period. And the panel and I are obviously free to disagree as to which is the more proportionate response there. But I would ask members to stick with the wording that I'm proposing and keep this as a requirement. I think this puts it on a stronger footing, particularly in human rights grounds, and support that amendment. But bearing in mind, again, apologies for the phrase, but we're not risking being faced with a zombie, Frankenstein, mixing up my monsters there, as a Frankenstein law, because of that other amendment, which, if it comes to it, my noted rejection of it on the order would be swapped at that point to be accepting of it. So I ask members to stick with my wording as Plan A. And I call for the appel. Thank you, sir.
That has been called for. Members are invited to return to their seats. And I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. Announce that the Fifth Amendment has been rejected, 14 votes for, 28 votes contra. Now move on to the amendment lodged by the Chair of the Environment, Housing and Infrastructure Scrutiny Panel, proposing parts 5 and 9 of the Fourth Amendment, which the greffier will kindly read.
Part 5. In Article 6, new Part 3, new Article 6G2N2, delete the following to which a police officer or a state's employee with a relevant enforcement or regulatory function has attended. 9, Article 14. In Article 14.4, new Article 15.2G, delete the following to which a police officer or a state's employee with a relevant enforcement or regulatory function has attended.
Deputy Chair.
Thank you, sir. It would be maybe useful also to hear from the Minister of Environment under this particular point as well, because of course nuisance is in his realm. But under the current drafting proposed by the Minister, landlords must wait for a police or state's officer to attend a property before serving notice for serious or repeated nuisance, which is outlined in Article 6FN. And this would be, as we've heard, 7 days. So in other words, the validity of using nuisance as a ground for serving notice hinges only on the attendance of an authorised officer at the property. The officers would not be required to gather evidence upon attendance. Our report collected considerable evidence on this, and the findings was clear. The presence of an officer does not in itself establish that a nuisance has occurred, nor does it shift the burden of proof away from the landlord. The burden of proof remains with the landlord, and the matter is ultimately determined by the court. Moreover, the States of Jersey Police have raised concerns about operational burden and legal ambiguity, and we heard the concerns about operational and resource pressure for the Housing and Nuisance team from the Minister for Environment at the Principals debate in July. So our amendment removes this requirement completely, ensuring the law is enforced, this requirement for a States officer, a police and a States employee to attend the property, to ensure the law is enforceable, proportionate and mindful of public resources. The members may have rejected the Minister's Fifth Amendment out of concern that safeguards are still needed. We still believe that the safeguard is already there, and it is the court that weighs the evidence and determines whether possession is justified. We don't believe an officer attendance on its own strengthens that safeguard, and we believe it only clutters it. Therefore, I urge members to support Amendment C1.
Is the amendment seconded? Yes. Thank you. Does anyone speak on the amendment? Minister.
Thank you, sir. Just to highlight the point that I'd made in the previous debate, that though I was down to be rejecting this amendment because the previous one was rejected, I'm now in favour of this one. Thank the Assembly following the rejection of Plan A to support Plan B instead, but thank the scrutiny panel for still having something on the table that represents progress. So I am in favour of this, despite it saying previously that I was not in favour of it.
Thank you, Minister. Does anyone else wish to speak on this amendment? Yes.
I'll be very brief, sir. The first thing I'd like to say to members is the nuisance referenced in the Deputy speech is not statutory nuisance, which I discussed at length yesterday. This is something completely different. But I just stand to support the Deputy and her amendment. I've discussed this change with staff, and we are considerably more comfortable than we were originally. As the Deputy said in her speech, the onus on staff and the amount of work that might have been created has been negated here, and I support the Deputy with her amendment.
Thank you, Deputy. Does anyone else wish to speak on this amendment? Yes, Deputy Hogarth.
Thank you, sir. Yes, and likewise, like the Minister for the Environment, I too am grateful for this amendment, because resources are always tight, and I wouldn't want to be in a position where this would fall on a regular basis to the police. Thank you.
Thank you, Deputy. Does anyone else wish to speak on this amendment? Deputy Joan.
I feel that I think that most of the points have been made, and so therefore I call for the appel to try and be as swift as possible in this debate.
That has been called. 4 members are invited to return to their seats. I invite the greffier to open the voting. If all members have the chance of casting their votes, I ask the greffier to close the voting. And I can announce that the amendment has been adopted unanimously, 43 votes for. Now move to part 6 of the Fourth Amendment, lodged by the Environment, Housing and Infrastructure Scrutiny Panel. I invite the greffier to read part 6.
Part 6. In Article 6, new Part 3, delete new Article 7.
Deputy Joan.
Thank you, sir. The draft law proposes a civil penalties regime in the secondary legislation, and separately new criminal offences in the primary law. Article 7 creates an offence for landlords who knowingly or recklessly give a false or misleading ground for serving notice to end a tenancy. This penalty for the offence is up to a level 3 fine of £10,000. This is a serious sanction tied directly to the new statutory notice regime, which is complex. And as we've already maybe admit within the Assembly, poorly understood for now. So, for example, the panel's report found significant uncertainty over how serious breach of tenancy agreement under Article 6 FG could be interpreted in practice. This ground allows landlords to give just 1 month's notice to tenants, regardless of how long the tenant has lived in the property, yet there is no clear objective test to what constitutes a serious breach, no statutory criteria and no published case law under the equivalent provision in the 2011 law. All stakeholders highlighted this lack of clarity. It is in this context where even fundamental grounds remain unclear that Article 7 would criminalise landlords for giving a reason later judged to be false or misleading. That is why the panel considers this offence premature. The evidence we gathered confirmed this concern. The Jersey Estate Agents Association warned that the proposed fine under Article 7 is very chunky and would create an adversarial environment, exposing landlords to severe penalties for mistakes rather than intentional misconduct. They also highlighted that there is no equivalent criminal offence in the UK where disputes over possession grounds are resolved through the courts, not through criminal sanctions. The Jersey Landlord Association echoed this, questioning whether landlords should be criminalised at all for giving a false or misleading ground for possession, when it is ultimately for the court to decide whether the ground is valid. The panel also believes that these new civil and criminal penalties should be developed together in a tiered framework, with civil penalties for low-level breaches and criminal penalties reserved for truly malicious, I'm getting tired, I apologise, malicious misconduct. The Viscount described the proposed civil penalties regime as unusual and highlighted a lack of clarity around enforcement, making it impossible to advise how it would work in practice without further development. Amendment D1 therefore ensures gives the time is taken to get this right. By moving Article 7 into secondary legislation, it allows for proper consultation for civil and criminal penalties to be designed holistically, and for this Assembly to approve a penalty framework that is proportionate, effectively targeted and well understood. The Minister has pointed to other offences, Articles 7G and 13Q, as though the panel should have removed them too. They were not the panel's concern. It's Article 7G which requires landlords to provide the Minister. Article 7G requires the landlords to provide the Minister with rent information. Failure to do so, or knowingly providing false information, carries a level 2 fine of £1,000. This is standard regulatory offence, clear in scope, low in penalty, and designed to support data collection. The panel did not have a problem with this. Article 13Q makes it an offence to act in contempt of the tribunal, the rent tribunal, with penalties of up to 6 months imprisonment or a £10,000 fine. Again, this is a standard contempt provision, consistent with how other Jersey tribunals operate. These offences are not new or contentious. They are inconsistent with existing practice elsewhere in law. Amendment D1 targets the new criminal offence in Article 7 only to knowingly or recklessly give a false or misleading grounds for notice. This is directly tied to the new statutory notice regime. That is where the panel's concern lies, because these notices are new complex and already poorly understood. Therefore, we urge members to support the panel's amendment so civil and criminal penalties can be designed holistically, that expanding the penalties regime can be done following proper consultation, and for this Assembly to approve a penalty framework that is proportionate, effectively targeted and well understood. And I'd just like to reiterate that the panel is not saying that we shouldn't have civil or criminal penalties. What we are asking for is that they are moved into secondary legislation so that the framework can be designed together as one, and that can then come back to the Assembly so that we can see that proportionality in conjunction with more guidance that the scrutiny panel has asked for under those different aspects of the list, the statutory notes, reasons for notice, to understand a bit more what does a serious breach of contract mean, what does nuisance, single nuisance or repeated nuisance actually mean, and there are elements that potentially would need more information on that. Thank you.
Thank you, Deputy. Is the amendment seconded? Yes, sir. Thank you. Minister.
So it's actually for some questions for the Attorney General, if that's okay.
Yes.
So I wondered if the Attorney General could assist the Assembly when it comes to the offence in the proposed Article 7 of the draft amendment law. Could the Attorney General advise the Assembly as to whether this kind of offence is unusual in the context of Jersey law, or whether this kind of offence is something that we see more often across the board?
Attorney General.
So, in terms of the type of offence, knowingly or recklessly giving false or misleading information is a fairly standard offence that appears, well, I wouldn't say regularly, but it's not infrequently across various statutes. They're usually regulatory statutes. So it is a fairly standard offence. It requires intention in the form of knowing, intentional or reckless behaviour. And if that intent is not there, then that is a defence to a prosecution. Having said that, having heard what the chair of the scrutiny panel has said, I would accept that the offence is although it is a not uncommon offence to see in other statutes, it is, I would accept, it has not been used before in relation to termination notices to terminate, giving reasons to terminate residential tenancy agreements. So I would accept it's not being used in a similar situation because we're not in that similar situation. But in terms of the Minister's general question, well, look, is this sort of offence, is it used in other statutes? Yes, it is. It is used in regulatory statutes quite frequently. And it requires intention. It was subject to, when any new criminal penalty is introduced in legislation, we go through a process by way of due diligence where we do a penalty review, we look at other statutes across jurisdictions to see if we can find similar sanctions, and I can confirm that sort of penalty review took place in this case, and so the level 3 fine, that is not out of proportion to this sort of offence. That is a maximum fine, so it remains within the discretion of the court to tailor that fine to the appropriate circumstances of the case and introduce a lesser fine if that is appropriate. Thank you, sir.
Thank you.
So can I follow with a supplementary?
Yes, you may. There are other people who want to ask questions as well, I think. Yes.
Thanks, and I thank the Attorney General for that answer. There was mention of the intention of the person behind this. Could the Attorney General elaborate on how that intention would be assessed, and at what point would they regard that as meeting the public interest to proceed with the prosecution for this kind of thing?
Attorney General?
Yes, sir. So one would look at the notice. If there is a complaint to the police, there would be a complaint from the tenant to the police, and as part of that complaint, the police would look at the reason that the landlord gave when terminating a residential tenancy, and would seek to interview a landlord in those circumstances. And if the landlord had a genuine and honest belief that the reason that they gave at the time of giving notice to end a tenancy, that was their genuine and honest belief, then that, provided it is not fictitious or mendacious, then it is likely that the police would accept that reason, and that a prosecution, an advice file would not be submitted to my department, and that a prosecution would not be pursued in those circumstances, because the relevant intention there under this proposed offence would not be present. Even if the evidence was there that the landlord had knowingly or recklessly given a notice that contained a false reason, then we would still go on to consider the public interest test in a prosecution. So if a landlord was old or infirm or had some sort of mental incapacity, then we would consider the public interest in pursuing a prosecution in those circumstances. And if there were appropriate mitigating circumstances, we might consider that a prosecution was not in the public interest.
Deputy Miller.
Sir Deputy Mayor's asked my question already.
Constable St Mary, was it a question of the Attorney?
Sorry?
Was that a question of the Attorney you had or not? Do you have a question for the Attorney, or were you wishing to
No,
speak?
not for the Attorney, let's speak to
Deputy Talia, question of the Attorney?
Thank you, sir. I know that part of the concern here is that the law hasn't been tested. Obviously, this law is not in place yet, but the residential tenancy law. Could the Attorney General confirm that the court, if a case does get to court, that the court has always got a test of reasonableness, so whether the behaviour of the landlord was reasonable, and could, if the landlord could prove that they were behaving reasonably in all circumstances, that would be considered a reasonable defence, so to speak.
Attorney General.
Well, that isn't written into the law, but this is we're talking about a criminal prosecution, so that we're not talking about an action in the Petty Debts Court. If a prosecution is brought, then it would be brought in the Magistrates' Court, and the magistrate would need to decide whether the offence was committed beyond reasonable doubt. So she would need to be sure that the offence had been committed. Now, if the landlord had, in all the circumstances, behaved in a reasonable way, it is probable that the high bar for a successful criminal prosecution, the standard of beyond reasonable doubt, would not be met.
Deputy Scott, was there a question of the Attorney?
Thank you. Just when you were talking about, when the Attorney General was talking about the balance of probabilities and the proof of recklessness or of intention, I was just trying to get a bit more of a handle. How do you prove, what investigation, what level of investigation would need to be done in order for the evidence to be accepted to actually prove that that intention, was actually there, or recklessness?
Attorney General.
Well, so to be clear, I was not referring to the balance of probabilities, because that's the civil test, that's the civil standard for the burden of proof. So the criminal standard is beyond reasonable doubt. So the court must be sure that the offence has been committed. and the court looks at all the evidence that is available. If the landlord has given a reason that is wholly at odds with other evidence which related to the circumstances of the tenancy, the circumstances of the landlord at the time that notice was given. So if the landlord has said that they've given a reason that they wish to sell the property, but then don't sell the property and in fact re-let it the next day, that would seem to be a situation where a court could be sure that the notice, the reason given the notice, was a false one. But the court has a wide discretion to look at all the available relevant evidence, but it has to be sure that the offence has been committed.
Yes. Question of the attorney, or do you want to speak?
Just a brief one, sir. I'm not sure how relevant it is, but do criminal penalties usually sit in primary legislation? Is it a rarish occurrence for them to be placed in secondary legislation, or is it not that relevant?
Attorney General.
Sir, it is usual for criminal penalties to be in primary laws, or they can be in regulations which are also voted on by this Assembly. Where they are not usually is in ministerial orders, which are not voted on by this Assembly. So, provided that they are in laws or regulations, that is the appropriate place for them to be.
Thank you. Conataba St Mary.
Thank you, sir. And I simply wish to echo my chair's concerns as to the introduction of criminal sanctions in this arena. If there's one single reason why landlords might be dissuaded from letting property, I suggest that this is it. To repeat the chair's point, we're not saying this shall not be looked into. It is anticipated that there will be further research and discussion, consultation on the question of civil penalties. And surely that is the right time to introduce or to consider whether criminal penalties are appropriate or not. I perhaps should have asked the question of the Attorney General in the sense that I know that under the present 2011 law, in Article 16 jurisdiction, the final paragraph reads, "Nothing in this article shall be taken to confer jurisdiction in criminal matters on the court." And I assume that is there to assure landlords that criminal activities are not contemplated, and I do not know why that is not being maintained. As I say, sir, I do think this is a very dangerous provision to maintain at this juncture. I have consistently the last couple of days voiced my approval for a public hearing of the main proposition coupled with the scrutiny's recommendations, and we've arrived at this stage where we are indeed considering them. I fear, sir, that if this provision for criminal penalties were allowed to stand at this junction, I would probably be persuaded to vote against the proposition as a whole, which I think would be a great shame. I see little merit in fighting the battle at this stage, and I would actually urge at this stage whether the Minister might consider accepting the panel's recommendation so that can be discussed at a future date. But I say I do maintain my basic concern that on behalf of landlords that considering the possibility of penalty is a grave imposition, and it would, whilst I appreciate the answer is, well, they would only be convicted in certain circumstances, it does give a tenant some sort of leverage to almost have a reverse of a revenge eviction scheme that contests the reason why he's doing it, and that might persuade a landlord to settle on certain basis, simply not to get involved in criminal proceedings. If the purpose of this legislation is to encourage landlords to be maintained in the market, I ask that this provision not be maintained. Thanks, sir.
The next speaker I've got is the Minister, unless you've got a question for the Attorney, Deputy. So the Minister next, and then you. The Minister.
Okay. Thank you, sir. Obviously, I'm in the hands of the Assembly ultimately here, and this isn't a Frankenstein law territory. Again, if this were adopted, it wouldn't be killing off the law. So I do want to maintain my position on it, though, and explain why. The amendment from the panel proposes to remove certain criminal penalties from the primary legislation and place them into secondary legislation with the stated purpose of allowing more time for consultation and more careful decision-making on the penalty regime. Now, obviously, at first glance, that sounds reasonable enough, but when you look at the close detail of this amendment, there are some inconsistencies and things that I regard as problematic with it. So the first point is that the amendment doesn't actually remove all the criminal offences from the law. It only removes Article 7, whilst leaving other offences, such as those in 7G and 13Q, in place. So it's not a broad principle about all offences in there. It's actually much more direct. So we would end up with a law that has some offences in primary legislation whilst others are hived off into regulations, and that is an inconsistent approach. But having heard from the Constable of St Mary just now, that there hasn't really been provided a clear explanation as to what the tangible problem with the proposed offence in Article 7 actually is. The narrative around it is more about the nervousness of some stakeholders as a result of it, but they haven't seemed to have spoken of whether those misgivings are actually justified based on the substance. And that's kind of why I don't really want to give way on it, because we do need to stand firm on misinformation, and we need to be clear about what the law actually does and not make decisions on law based on some people's misreading of it rather than what it actually is. So, is that the purpose of this, is to allay the nervousness of some stakeholders rather than there's an actual problem with what's proposed in Article 7? Because based on what the Attorney General has just said, it doesn't appear that there is actually an issue with what is in Article 7. What we're talking about in terms of this offence is not unusual or controversial. Article 7 creates an offence of knowingly or recklessly providing false or misleading information in relation to the Article 6 grounds for notice. That's pretty standard. It's designed to capture deliberate, malicious misconduct, not honest mistakes or unforeseen changes in circumstances. And the Attorney General has outlined why it's inconceivable, really, that a genuine, honest mistake would end up being caught up in this and somebody would end up with a criminal record and a big fine as a result of it. The levels that you have to get to, not just in terms of there being clear, undisputable evidence that the conduct was malicious or and the rest of that, but on top of that, the public interest test in it as well. The threshold is so high to be able to get that it's just not going to capture somebody who was honest but perhaps misread something, made a mistake, or had their circumstances changed. So if you're, and the Attorney General used this example, it's a good one. If you're somebody who issues notice to your tenant because you were planning to sell the property, you issue notice, the tenant leaves, you're marketing the property, it's on the market for a while, you realise that actually now's not a good time, you're not likely to make that sale, and your circumstances have therefore changed and you re-let the property, you're not going to end up anywhere near a court as a result of that, because that was clearly decent and honest and it was not seeking to subvert the law. But if you were somebody who just decided you didn't like the look of your tenant and wanted to get rid of them and said, I'll just tell them I'm selling, and then you issue them notice, they go, and then 5 minutes later you put the property up to be let by somebody else, you've clearly lied. There's clear problem there, and there'll be evidence in that. That's the kind of circumstance that it is targeted at, and nobody yet has explained why that shouldn't be the case. The Attorney General has reviewed the proposed offences and confirmed that they are proportionate, and I hope that that does provide members with reassurances here. But sir, on the point about civil penalties, the substance of the amendment centres around criminal offences, but the narrative does make reference to the separate regulation-making power for civil penalties. So just to be clear, and I did make this point in an earlier amendment, that the draft amendment law does not contain a civil penalty regime. Doesn't contain it, it contains regulation-making powers so that we might do that in the future. So it's not all of a sudden loads of stuff being thrown onto the table immediately, including that regime as well. It's actually just a very standard clear offence of people who have been malicious in their misconduct and fundamentally dishonest, and that is obviously behaviour that nobody should be standing up for. So that the civil penalties regime is not literally what the amendment is about, even though it's been mentioned. So I hope members don't conflate the two because of where they are sitting differently in what is proposed. So my preference is that this proposed offence, which is perfectly decent, perfectly standard, and will set such thresholds that it is just not going to happen that anyone engaged in honest mistakes is ever going to get anywhere near it, that I would hope we could stick to that. It's not the end of the world if members choose not to do that. It won't kill off the law. But it is, I think, right on a point of principle that if we're not actually going to say what's wrong with the proposed offence, because I don't think anyone can say what's wrong with it, because it is right, and it's probably where we get to in the end anyway, then we should not be afraid to make that point in the interests of good lawmaking at this point. So I would urge members to reject the amendment, but I'm of course ultimately in the hands on that.
Thank you, Minister. I see the time.
I propose adjournment, sir.
9:30. Members content to adjourn now? Adjourn till
So
tomorrow.
can you take my name off the list for speaking in the morning, please?
I shall do that.
Because I think the Minister's already spoken and I probably don't need to speak.
Thank you, Deputy.